Any mention?
Please, Lordship. Lordship, back to mention item number 35, Lordship.
Number?
35, Lordship.
25?
35, Lordship. The conducting counsel is unavailable, Lordship, today. Kindly allow us 2 weeks' time.
Who's not available?
PP Mehdi, Lordship.
I don't think court's inclined to grant any more time in this matter.
Lordship, just 2 weeks' time is kindly be allowed, Lordship.
Court has been very kind to them. And
Yes, we don't incline even. You'll be called out. You
Lordship,
call your
yes.
other arguing counsel, whoever's here, local one. Who was arguing that matter?
Lordship, who is led
No
by
peers
Lordship, Senior Counsel Ken Chaudhary is leading us.
Doesn't matter. Just a change cannot be an excuse. Yes. You're ready with the matter? We'll take it up.
I'm not a brief holder, Lordship. Mr. Mehdi is there. He's from
Sir,
Gauti, most
unavailable.
probably today also with the VC link, Lordship. Can come next week, Lordship.
Otherwise, we've been too lenient. I mean, every time, and this case is, it's a civil dispute totally, and you're trying to.
Next week, Lordship.
Just
will-
1 week's.
Next week doesn't mean the convenience of the court or convenience of the counsels.
Lordship will-
Okay, mentioned with me on behalf of the housing council is not available in court today. Just a matter 2 weeks after vacation, yes.
after vacation.
Lordship.
2 weeks after vacation.
File your-
Yes.
Please, Your Lordship. Your Lordship,
Avoid you asking for time and again. That's what, yes.
Your Lordship, I pray for item number 29 and 30, Your Lordship, to come 2 weeks.
You're there? You
Yes,
file
sir.
affidavit?
Yes, we have filed affidavit, yes, Your Lordship.
Yes, 2 weeks, yes.
Also 30 and 39, Your Lordship, same matter.
Why?
One is WPC, one is contempt, sir, same
the
petition.
same matter?
Yes, Your Lordship.
Okay. Or connected?
Yes, Your Lordship.
Okay.
Hurry up.
Lordship, I beg to mention item number 24 and 25 for a week, Lordship, as conducting counsel, Mr. S. Upadhyay is not well.
Mr.
Upadhyay,
24 and 25.
yes.
You're there?
Yes, Your Lordship.
How long?
1 week, Lordship.
Week, okay.
And the pledge.
Yes. For now.
Lordship, I beg to mention item number 26. The conducting counsel is on medical grounds, so matter may be taken up after 2 weeks.
Who's conducting counsel?
S. Pandey.
What happened to him? Who's here for the petitioner?
His
26?
Yes, his wife was hospitalized.
Huh?
His wife was hospitalized.
Who's for the petitioner? You have taken consent?
Yes.
26?
Yes, item number
Taken
26.
consent of the petitioner?
No.
No. Dr. Muzika, your parents matter. 26. You inform the other opposing counsels, it will take time.
26 and 27, Your Lordship.
What's the matter about?
This is regarding we had
School
challenged
teacher.
the school teacher selection process.
Any urgency?
No, Lordship. They are continuing in the post, Lordship. Mr. Pandey is appearing for the managing committee.
27 connected.
26, 27 and 28, Lordship. Concerns the same school.
Okay. What is your name?
T.M. Marak.
First time mentioning today.
No.
First time appearing in court. No, you mentioned before.
Yes.
Yes, you take consent with the other side before you mention, okay?
Obliged.
Item number 40, I was directed to produce the record. So I have received the record today, my lord. So I would like to 40, my lord. I am for the respondent district council, my lord. I have taken consent of the petitioner, my lord. So, my lord, give me some time. It's a bulky, it's a bifurcation and also termination of the appointment of the Gabuda. So, my lord, if it can be listed on 2nd of December, my lord. 2nd of December, my lord. I will be out of station, my lord.
Yes, 2nd December.
2nd of December, my lord. Hello, Mr.
May please, Your Lordship, I beg to make a mention of item number 41, Your Lordship. I humbly pray, Your Lordship, kindly this matter may be listed after 2 weeks, Your Lordship.
Why?
Your Lordship, the conducting counsel, Mr. A.G. Moman, is indisposed, Your Lordship. Interim order may be continue, Your Lordship. In this matter, there is interim order, Your Lordship.
Interim order, then we will vacate it. With interim orders, and court will not be inclined. Okay, since he's not well,
Lordship.
not appearing some other court.
No, Your Lordship.
Okay, after 2 weeks, interim order continues.
I know that, Your Lordship.
I beg to mention item 36. Just after 1 week, Lordship.
Who's the pin for the other side?
My lord, I'm for the state.
Mr. Sheikh is for the respondent, Lordship, private respondent.
Yes?
Mr. Sheikh is for the private respondent.
Where's
He's
Mr.
also
Sheikh?
not available today, Lordship.
Okay, 2 weeks, yes.
May please, Lordship.
Yes.
Lordship, I beg to mention item number 31, Lordship.
30?
31.
Yarab Borlang Khan.
Yes, Lordship.
Yes.
Lordship, we are ready with the matter, but if
Your objection?
today
Your objection, then the matter will be taken up.
Lordship, I was not very well, Lordship, this weekend, Lordship. Couldn't prepare properly.
You were?
I was not well this weekend, Lordship. There was a flu.
kindly may have it next week, my lord.
After 1 week, okay.
Much obliged.
Yes.
Much obliged.
Item number 1.
Item number 1, may I please, Your Lordship, I'm according to video conferencing.
Yes. What is this?
My lord, the petitioner is a company and basically deals with the RTO registration of the vehicles, and the petitioner being the power of attorney of the vehicle owners, my lord. The petitioner has filed for the reassignment of vehicles before the RTO.
Not unclear. What is your prayer? What is your prayer here? What do you want?
My lord, the petitioner gives the direction of this honorable court to the opposite party RTO authorities to approve the phrase representation and application for the reassignment of the vehicles and to register the vehicles by following the due procedure of law.
This one is for registration of old vehicles.
Yes, my lord. My lord, the vehicles are previously registered before the government of Lakshadweep, and now they are reassigning the vehicles within the state of Meghalaya.
After
And
sale?
for that purpose,
After sale?
yes, my lord.
So
Yes,
why
my
would
lord.
this RTO is not registering the vehicles here?
My lord, here the problem is, my lord, there are two types of state. One is Bahan state and others are non-Bahan states. Some states are still using the older version of Bahan, in which they are not uploading the NOC provided by them online, and for that purpose they have provided their email IDs for the verification of the NOC, and which is not known to the RTO authorities. So they are denying the registration by saying that the NOC is not available in online format, which is due to the government of Lakshadweep is not using the new version of Bahan. And also they have insisting the physical verification of the vehicle, my lord. When the same section has been amended and nowhere in the Motor Vehicle Act, my lord, the physical presence of the vehicle is insisted upon during the reassignment of the vehicle.
Yes, Mr. Sankar.
Lord, I'll require some instruction.
Sir, what is your name? S. Samar.
My lord, Shivani Samarpita Oja.
Yes, sir. MS S. Samarpita Oja. Yes,
Oja,
for the
my lord.
petitioner, issue notice. Mr. N. Sinkon is present, except notice on behalf of
All the respondents.
all the respondent for the notice called for. Just after 3 weeks for instruction to affidavit, yes.
Obliged.
Item
Oh,
number
yes,
2.
my lord.
Item number 2.
Please, Lordship. Lordship, this is here regarding the teachers. Your Lordship, what happened? I was appointed by the managing committee of this school in the year of 2008, Your Lordship, and then on a regular service. And thereafter, I was replaced with the private respondent, who is the wife of the headmaster. And then thereafter, there was two separate inquiries conducted against me. by the state respondent. State respondent has already.
What inquiry? Why?
The inquiry with regards to removal of my removal from the sanction post and replacing with private respondent, because I have filed a complaint for revocation of my appointment as a regular teacher, as a sanction teacher, and then to replace with the private respondent, which is the wife of the headmaster. The state respondent, after conducting two separate inquiry, it was in my favor, stating that that appointment and replacing is illegal.
You were a duly appointed teacher approved by the.
Yes.
Then what happened?
Then
you were removed from service.
Yes, without any show cause, without any meeting. The managing committee by they themselves have the meeting. There was a meeting held, and there in the meeting they have revoked my service from the regular
post. They removed you and put the headmaster's wife.
Yes, that is the case. And then two separate inquiry was there. It was two separate inquiry was in my favor only.
By whom?
There was District Joint Mission Commission.
By the
District Joint Mission Committee, that by the state respondent. Two separate.
Coordinator. Not
Lordship, yes, coordinator. And then they said that the illegal appointment of the private respondent was illegal, and then they have requested the managing committee to replace, to reinstate in the service. But after that, there is no question. And another separate inquiry, there was another three inquiry was there. Another three inquiry said that.
Three inquiries.
Yes. Three inquiry. Last inquiry.
Yes.
Last inquiry said that my appointment was illegal. That was in paper.
Where is that appointment illegal?
Yes.
Which page?
The appointment. That is first appointment is the page.
No, let's see your.
Yes.
Where they removed you and said
remover. Yes. That first that. May I take you to the annex? That's page 37, my lord. Page 37. That's a relevant portion, my lord, because it is a start frame page 35. But I will just read it. 37. This is the inquiry. First inquiry report by the block mission coordinator. Silsila block.
This is November 23.
Yes.
Yes.
Page 37, my lord. Page 37. May I read it? The School Managing Committee in each SMC meeting here on 28 January 2017 revoked the Abdul Rahim from the sanction post. I am the Abdul Rahim, my lord, the post of assistant post teacher. And again in each SMC meeting here on 6 February 2017 decided to issue a fresh appointment order to each teacher as follows. Then this is last one is this is Johidul Islam headmaster, then the Islam Ali, the Subindro Kutun, then this is the Srimati Hasina Banu Bigam, assistant teacher, post teacher. And then though the fresh appointment order as proceeding of the SMC here on 27 January 2017 and issued to their teacher on 6 February 2007 was approved by DMC West Garu Hills, Tura, as per memo dated so and so, and post teacher was approved by the joint DMC Dadengri subdivision wide memo so and so on 20 September 2022 after the gap of over 5 years. In view of the above facts, after thoroughly.
It is in your favor.
Yes, this is in my favor.
The one against you.
Against me, lordship. That is last. Against me is the. It start from page 46, my lord.
That's what
page,
you want to
yes,
what
lordship.
agreed with.
Yes, annexure 16. Here in the last portion,
yes,
they have mentioned. I will just read it, the para 7, my lord. Where the sir, no action taken report was submitted by Joint District Dadringil, letter dated so and so was issued by the undersigned in pursuance to your letter dated so and so. The take appropriate action and dispose of the matter. The DMC Dadringil had to examine the matter and approve of the complaint by not considering Abdul Rahman as post teacher. The white dated 13/05/2004 submitted to you. Then further, it is directed that you examine matter as a post teacher in Sikarta SSS Upin totally in all parties involved. The case more were summoned to 1st August 2004 in the office of the chamber, undersigned with a letter so and so. Verbal statement was taken from all the stakeholder. In summing up the matter, it may be concluded that the inquiry report dated so and so, as well as the recommendation by Joint DMC Dadingri, White 13 Y1303/2004 was not based on the document related to the case, like letter so and so, as well as the cancellation of the order dated so and so. Further, it is observed that Abdul Rahman was never considered.
That earlier inquiry report was not based on the actual.
That is there, yes.
Not that allegation. That's what he said. He said that some letters not taken into consideration, documents were not placed.
Yes.
And so, Abdul Rahim was never considered for teacher.
Yes.
So you never for teacher also. And Abdul Rahim for teacher could be, but no approval could be produced also.
This is the last one. But other
Yes,
two inquiry.
Then you're nowhere. When did you?
No,
when
Lordship,
were you taken out from service?
I was taken out from now. Actually, I'm still in service there only. I'm still teaching. They allow me, but they are not paying the salary.
How many years have you worked?
Now since from 2008.
You've been working on salary.
From the day when they have removed me on 26 January, they have not paid the salary. It is from 28 January 2017 till date, my salary has not been paid.
So now it's only 7 years.
Yes.
So no problem, no salary also.
Yes, Lordship, because from that day when they remove me from the sanction teacher, they have not paid. They have reinstated another.
How are you surviving?
I'm just surviving because just like that, my lord. I just
like that.
Why whenever they are doing some work.
Very lucky. Yes, how was it possible? But even then, if you're not a teacher, you have no case. Anyway, heard Mr. P.D. Sama issue notice returnable in 3 weeks. MS Shyam acceptable. We have respondent number.
1 to 5, 1 to 6.
1 to 5, my lords.
1 to 5.
Steps to be taken on the review
Subdivision is done in
yes. Accordingly also. But after the affidavit, yes.
Item number 3.
Much obliged, Lordship.
Yes, Mr. Chandra.
My lord, this restrictions are having as Havildar ORL in Assam Right Legal. They have not been extended the benefit of fast SCP on the alleged ground that fast SCP, benefit of fast SCP under the Government of India OMC 988. SCP. So, my lord, what happened? Actually, they are confusing that.
Same thing only regarding that WC 277.
Your Lordship, they are
2012 order. 2014 order. These cases, yes.
I'll file an affidavit.
I heard Mr. M. Chanda with so-and-so for the petitioner issue notice. Dr. N. Mozikal at GSCI with K. Guru, have all respondents. Just after 3 weeks for 4 weeks for affidavit. Same, still.
Same.
Using the same horse.
Sleeping people are still.
These were not there in the earlier litigation. Were they there, Mr. Chanda?
My lord?
Were they there in the earlier litigation?
No, they have not approved, my lord. They have not approved. They have not.
This is regarding first ACP, Your Lordship. First ACP.
They were given the other benefits given.
Upgradation, therefore they
upgraded.
Second and third, Lordship.
They were upgraded.
Yes.
Redesignation, therefore they have denied the benefit.
So they had treated upgradation as promotion.
That is a done and done case. That means now they're treating it as a promotion, later redesignation.
That's why they
so they will be entitled to the ECP.
Yes.
Then it's covered actually. Yes.
It's covered case.
Item number 4.
Obliged. Detail.
Wait, please, Lordship. Before my friend starts, Lordship, I filed a caveat petition, Lordship, this matter.
The teachers matter?
This is a school managing committee, Lordship. A copy may be served to me, Lordship.
Yes, Mr. Deb.
And for the respondent 5, Lordship.
Yes, seen a caveat petition filed by the caveator who has been arraigned as number 5 in WC 420 of 2024. So, stands discharged. Yes. You have received a copy? No.
No, Lordship. I'll be supplying in the course of the day, Lordship.
Yes, Mr. S. Deb and Council Petitioners, please that submits that he will
I'll
serve a copy upon the caveator.
Today.
Stop. This is the matter tomorrow. Tomorrow or when?
Day after, Lordship. Day after. Hello, Lordship.
Item number 5.
Please, Your
Lordship, I'm praying for 10
You're not
days.
filing anymore.
Filing,
Non-interested.
will you filing?
You'll be filing. How many times you've taken for rejoinder?
Only once, I think.
How many times?
Twice.
Okay, aspirate further 2 weeks and allow for rejoinder. No more after this.
Obliged.
Item number 6.
Whether Lordship will take up the matter.
Before any other crowd meetings.
7.
May we please your Lordship?
Yes.
This is the remaining part of the compensation, motor accident claim. This is one of the oldest case. We supposed to take steps on the judgment number 2, and that is the same address that there is no other address. It came unsolved. However, your Lordship, that there is a deadlock created by the previous judgment of this Honorable High Court, that first installment 50% to be released to the claimant, remaining 50% before releasing has to given some undertaking by the owner. But the owner came and pleaded as a pauper before the trial court. So my respectful submission, Your Honor, that since the deadlock has been created by the judgment of this Honorable Court, if that modification comes, then the money has been deposited by the insurance company to the tribunal.
Yes, Mr. General.
That can be cleared. I think this is one of the oldest cases.
Lord, I had sought specific instructions from the insurance company as to whether the prayer of the petitioner can be conceded to. Prayer is essentially for a slight modification of the 2009 order of this Honorable Court. Unfortunately, my Lord, the insurance company has pointed out that since a fairly substantial amount is involved, we'll wait for the adjudication by this Honorable Court. So as my Lord Senior had submitted, a matter may have to be adjudicated by my Lord.
Nothing for hearing. Mr. Manthan will finish it after 1 week.
Very good.
Yes,
Very good.
Mr. S.P. Manthan Council also submits that the correct address of the respondent number 2 could not be obtained, and a such service upon the said respondent has been frustrated. Yes. What you do a service then? Is it a necessary party? They are necessary.
Their presence would have helped both parties actually.
What to do?
But could not trace out, because earlier LD Chudri, now he also expert. He was a counsel for they pleaded for the, means she has nothing left with her.
In fact, the issue in this case is the non-appearance of the owner from so many years.
Yes. Concerning nature of the case, just a matter for hearing after 1 week. Yes. This also.
38, 8.
However, concerning nature of the case, let's matter for hearing.
8.
Your Lordship.
Agreements arrived at finished?
Yes.
Where's the agreement?
By tomorrow, we'll file it before the court.
We are not a party to the agreement, my Lord. If they give us a copy, my Lord, we'll examine it legally whether it's acceptable to us or not.
You're not party to the agreement also?
My Lord,
you have signed it?
My Lord. It has been settled, my Lord.
What is regarding?
Pension, my Lord.
Pension,
Family
release
pension.
of family pensions.
You gave a copy to
The person died, the father is claiming on one side and wife is claiming on the other side, my Lord.
I will bring on recording.
Yes, but counsel for the petition for respondent number 5 submit an agreement has been reached. The parent allowed to bring the same record. Yes.
Vacho.
Tomorrow.
9.
Your Lordship, I require 2 weeks' time to file my rejoinder.
2 weeks too long, Mr. Lasangluya. How many times you sought?
This will be my second, Your Lordship.
Rejoinder is not by right, you know that. What to do? 2 weeks further time. You file it, otherwise, as prayed allowed for your affidavit.
10.
May I place a Lordship? Respondent 6 is yet to file their affidavit.
Yes, 4 file 6.
Yes, place a Lordship. Only 6 is ready.
Lordship, I pray for 1 week's time, Your
Why?
Lordship. Last opportunity, Your Lordship. 1 week.
What difficulty are you facing?
I've not received the copy of the petition, Your Lordship.
You received copy to petition from the petitioner?
No, Your Lordship.
Till date?
I don't have a copy with me, Your Lordship.
What do you mean you have a copy? You've been served, correct?
I've not received from the petitioner or from the respondent, Your Lordship.
You've given her a copy?
I've not received, Your Lordship.
Receive what?
The copy of the petition, Your Lordship.
From the time it was filed, you received a copy of the petition till now?
No, Your Lordship.
Your Honor, I think earlier it was represented by another lawyer. Maybe they have not issued.
Oh.
First place, yes.
So you
They
get
have
a
just
copy from, fresh copy, photocopy it. Yes, Mr. Pasanti, please fill out for 2 weeks' time. He has submitted that a copy of the petition is not in his custody.
Sir.
Yes, as a counsel appearing, it's expected that all materials should be. Forget it. Right over another custody, sir. Just a matter of 2 weeks. Yes.
11.
Affidavit is required to be filed. We are filing it, my lord.
Was it ready?
No, we are filing it now, my lord. It's already there, my lord. They are in the registry, my lord.
You will serve copy?
Yes, Lord. They will serve.
What's the matter about Patta?
this matter pertains to gratuity, Lordship. This matter pertains to gratuity.
Gratuity. Mr. SD submits that the affidavit will be filed across the day. And this is matter for 2 weeks for agenda or for?
Agenda will not be required. They are doing a wrong calculation, my lord.
Okay. After this matter after?
1 week, Lordship.
1 week.
1 week not possible, my lord. Let it be on 2nd of December.
2nd December. Why is such auspicious date?
No, my lord. I'll be out of station.
Okay.
12.
Much obliged.
Your Lordship, I'm supposed to file affidavit in opposition. So I'll be filing it during the course of the day.
In the course of the day?
Yes. Responding to.
Serve them.
I'll be, before I file, I'll serve a copy.
Mr. Das, you already filed yours.
Yes, Lordship.
Then when we have
We'll be filing today in the course of the day.
who? Rejoinder?
Yes, Lordship.
Who the affidavit filed by 1 and 3?
1 and 3.
Yes. Z.A. Chaudhary? Yes, Mr. First S. Marpan, Learned Counsel for to submits that the affidavit on behalf of said respondent filed in the course of the day. Stop next para. Ms. Z.A. Chaudhary, counsel petitioner, submits the rejoinder to the affidavit filed by respondent 1 and 3. Filed in the course of the day also. You filed today itself. Just after 2 weeks is for the orders. Yes.
13.
I have filed my affidavit, Lordship.
Lordship, we've received your
Ready
Lordship.
the matter today?
No, Your Lordship will be filing a rejoinder, Your Lordship.
When?
Your Lordship, I'm praying for 3 weeks' time.
3 weeks.
3 weeks, Your Lordship.
We have filed one small case petition to get the interim order, Your Lordship.
When did you file it?
On the last petition, the case 118, Lordship.
When?
Petition, I filed the affidavit as well as the.
When?
The US filed, Lordship. Date is.
Come here.
It's on October 23rd October 2024.
Now that's how much, that's 3 weeks is gone?
Yes, Lordship.
Yes, today, this is the matter on 18th, that was on 24th then. Where's the objection to the miscase?
Your
You have no
Lordship,
objection?
Your
to
Lordship, we do
vacation of the
have an
order.
objection, Your Lordship. We'll be
Then
filing
you file it. Otherwise, then we'll vacate the order because where's the interim order?
That interim order is at page.
How's the miscase?
Annexure 1 in the miscase, page 10, my lord. In the miscase application. Page 10, annexure 1, the last one they have given. Relevant portion is page 11.
Page 11.
Lordship. Of my miscase. It was given only until the next date only. That also.
Mr. Kharmi, what order you have to produce 31/7/24?
I have enclosed it in my affidavit, Lordship.
The state government also is supporting. They have enclosed in that where it says that MTET is mandatory.
Where's Mr. Gautam?
Your Lordship, he is unwell. Your Lordship, grant us 3 weeks more time. Let the interim
3
order.
weeks time. Vacate interim order.
No, Your Lordship. Let
Then
the.
you have to, see the file and miss case.
Your
So
Lordship.
2263 will apply.
But Your Lordship, I'm under no instruction.
See, that is under instructions.
No, Your Lordship, I'm not under instructions.
Where's your affidavit? You will vacate interim order and then we'll post it for hearing.
Yes, Lordship.
Where's that order?
Let it continue, Your
It's,
Lordship. At least
page 11, Lordship, Annexure 3. Page 11, Annexure 3.
You will come prepared with the matter.
Your Lordship, then grant us a week's time, Your Lordship. We will file our objections also. Till then, Your Lordship, let the interim order continue.
You don't have MTET.
Your Lordship.
You don't have MTET qualification.
No, Your Lordship.
You don't have no MTET.
But you're not working now. It's like less correct.
No, Your
no
Lordship.
more working. Yes.
Yes. We'll give you opportunity. This is matter day after tomorrow for hearing on the misapplication. Be prepared. Yes. We will period your objection.
Your Lordship,
And
interim order
just to get main case.
Oh, yes, Your Lordship.
They have
Must
tomorrow,
be
be ready.
Oblige, Your
If you're going to do proper advocacy, you should be prepared to meet deadlines, and cutthroat competition. Remember that.
Your Lordship.
You can't have it easy. Yes.
14.
Yeah.
Must be
tomorrow. Yes.
Lordship, this as per on the last petition, Lordship, there is a pending payment of around 1 crore 3 lakhs, out of which they paid 36 lakhs. So another 2 or 3 installments are required to be paid by the MECL, Lordship. I pray that the matter may be kept pending, because the third time we are coming to the court, Lordship. Work was completed since 2022.
Because I've been told that by the end of this week, the security deposit amount will be released.
That's his money only you're keeping.
Yes.
This after 2 weeks for the orders on the period.
Well, we keep it after 4 weeks. By that time, we'll endeavor to.
Okay, Mr. S. Panel Counsel for the Respondent Corporation submits that the further payment is being organized. Further payment will be made to the petitioner within 2 weeks. Yes, this is the matter of 3 weeks for the orders.
Much obliged.
15.
My lord, I am seeking a day's accommodation. I'll file my affidavit, my lord. I am for the respondent number 2.
Why 1 day?
My lord, just some signatures are not yet come, that's why.
What's the matter about? FCI?
This matter relates to delay payment of interest on the gratuity. The division bench had allowed.
Division bench has allowed 6%, and against which there's a SLP is being prepared. But anyway, they are seeking the benefit of the division bench by filing a writ petition, my lord.
Well, what had happened that
1 year over since the order of division bench. That's why they come, huh?
Not 1 year.
Then you didn't file contempt, why?
No, it's not 1 year, my lord. It was passed recently, my lord, on the 8/11 of 24. Then thereafter, what happened? Few petitions were left.
8/11? 24?
Sorry.
That was passed.
I'm sorry. This was passed on
16/8.
16. Sorry.
16/8.
Last day of justice, last year justice. Okay. What do you want?
Well, so far we are concerned that yes, since there were some petitioners, they were left out. So we had filed, these petitioners are 16 in numbers, 95 petitioners who were part of the voluntary.
It's the same as Microfed matters only.
Yes, yes, my lord, it is the same.
We are just left out. We are claiming the benefit of the judgment that was passed. So they have taken ample time to file.
Will it be on place for the 1 week's time to file?
1 week, my lord.
Leave it, yes.
Obliged.
16.
I'll be praying for 2 weeks'
Read the
time.
affidavit.
I pray for 2 weeks' time, my lords.
Instructions not received.
Instructions received.
What's the matter about?
This is not payment of contract bill, your lordship. They have admitted that's the department, the
They
liabilities.
admitted in instructions also that you have to
Yes.
pay.
Lordship, the conducting counsel is Mr. S.A. Sheikh.
He's here just now. Where is he?
No, he's not here, my lords. He's not here today.
List after 2 weeks for affidavit by respondent.
Much less, lordship.
17.
My lord, the lordship fixed this matter for lordship final consideration, my lord. So far as my instruction is concerned, I'm still running the village as a headman of the village.
Last time, my lord, I had submitted that this is a fit
What
case.
instruction does Mr. Zura have?
My lord, if the matter may be disposed of, then it will be taken up by the tribunal. We will participate. We'll comply to whatever order that's on the pass.
Set aside the impugned order. Let matter go to tribunal.
Impugned order by whom?
Yes.
My lord?
Who passed impugned order? That one man.
Yes, the EM by himself had passed the order.
My lord, impugned order page number 60 and 64. Page number 60 and 64, ma'am. 60.
64 is the actual order.
Was that Soyong and that millimeter?
Yes.
Yes. Petitioner is whom?
Petitioner is the headman of the Malagat village A and B. Web page number 60, district council.
The petitioner, who is stated to be the headman of Maulangud A village. The petitioner number 1 is said to be the headman of Maulangud A village, and the petitioner number 2, the headman of Maulangud B village. Before this court being aggrieved with an order dated 67, right? Where's the order?
My daughter,
64.
64.
But it's
Page-
dated 22.
Yes, 22, and then the page 60 also, my lord.
Page 60.
This is 24.
23rd September.
With the order dated 13 June 2022 and order dated 23/9/2024, whereby the executive committee had ordered that Maulangud village would fall under the administration and jurisdiction of the Williams Imship, that is respondent number 4. Respondent number 4. Stop. Next para Mr. H.L. Chandra is going to counsel with MS M. Hajong has submitted that the executive committee, the executive member had exceeded jurisdiction in passing the impugned order, inasmuch as the matter concerns a territorial jurisdiction of the Lingdorship of Soyong vis-a-vis the Williams Imship, and the same should have been adjudicated before a duly constituted tribunal as given in the Saad Act, so-and-so Ilaka Act. So, what's your further submission? Apart from that, what's the other submission?
My prayer is to set aside and refer the matter to district tribunal. The tribunal has
Just only already said that. Any other submission? No. I submit it as the orders without any jurisdiction.
Yes.
The same may be set aside and the matter referred to a tribunal to be constituted by the respondent number. Number 1. Yes. That's 1 and 2. Stop. Next para. Mr. Titi appearing for the respondents 1, 2, and 3 has also concurred submission and has fairly submitted that it appears that the matter taken up by a single state member, and it would be in interest of justice if the matter is taken up by the tribunal constituted under the Ilaka Act. Mr. Ravi Jarwa appearing for the respondent number 4. Brackets M. William also submits that any order passed with tribunal will be they will abide by any order with the passed with tribunal in any proceeding if the same is instituted. Stop. Having heard and consent party, next para, having heard and consent for the parties, and having perused the materials report, it is seen from the face of the impugned order dated 13 June 22 itself that the same is authored by the executive member in charge of the administration on his own, and further the notification and the second impugned order whereby this order has been implemented. By the second order is a notice is a notification regard to the said impugned order. In view of the submissions on the council parties, this court therefore directs that the respondent 1, 2, and 3 constitute an appropriate tribunal to go on to the matter on the. When will you go and present it? On
a month's time.
On application being filed for the executive committee. Yes. Accordingly, this matter is disposed of direction that the aggrieved party, that is the petition 1 and 2, shall approach the executive committee, who, on receipt of an appropriate application, shall direct for a constitution of a tribunal to adjudicate upon the matter in issue. Stop. Notice should they will know notice. The same thereafter shall be disposed of in accordance with law. Consequent of direction, the impugned orders dated so and so shall also stand set aside, and the directed status quo shall be maintained till the proceedings or other orders are passed by the competent by the competent authority. Stop. Mr. Chairman also prays that 1 formal week's time be given to allow the petitioners to present their application. Prayers allowed. Accordingly, the matter stands closed and disposed of. As ordered above, closed and disposed of.
18.
May I please, Your Lordship? Lordship, the petitioner here, he has received all the dues payable to him, Lordship, so the matter may be disposed of.
This is which MTC?
Lordship, so she's the petitioners also issued a no dues letter. So on account of a departmental proceeding, some increment had been withheld, that's been released. 8,17,755.
Mr. S. and Learned Counsel for the respondent number
3 to 5. 3 to 5.
Today has produced a communication dated 28/10/2024 showing that the arrear increments in full has been released to the petitioners, also acknowledge acceptance of the same as full and final settlement. Embassy Motho submits that the matter may be closed accordingly. In view of this development, the matter stands closed and disposed of. Stop a copy of the communications taken on board made part of the recording.
19.
Motion 19, 20 and 21.
Yes.
They're again praying for the retirement dues. I have instructions. I may be granted about 5 months to release it.
It will dispose 5 months. Yes.
Foolish.
22. 22.
Yes, so the appearance to the council.
We have served the copies, my lord.
Mr. Dindor not appearing.
Even personally, we have served the copy to a senior, but it seems there's no instructions.
Yes, though it's been submitted that notice has been served upon 3 and 2 to 5. No appearance made on their behalf today. So yes, what do you want?
Well, we had prayed, my lord, to allow us to do our business, my lord.
Yes, next for Mr. S. Kanti submits that the instant petition has been filed for non-renewal of trading license of the petitioner who's running what business?
My lord, fabrication, my lord. Steel fabrication.
Who's running a steel fabrication business. What is the submission? When do you submit it?
My lord, it was submitted in the year 2017, my lord. 17. Thereafter, time to time, we had gone to the office, and my lord, and on last 2 occasions, we had given the representation, my lord. In spite of that,
Learned Council submits that though application for renewal had been made as far back in the year 2017, and reminders, and that time to time the petitioner had approached authorities and also sent reminders on. Give the dates.
Excuse me, sorry.
On.
It is on, my lord.
On.
One is on, my lord, 3/6/19.
Where is that?
It's at page 26, my lord, Annex 5.
The matter has been sent on page 27.
Yes, 26, my lord.
26. On 3/6/19, and again on.
Again on, my lord, 21st 6/23, my lord.
6/20/23. There has been no response from the district council authorities. Stop. What else? Then, if expired now, you got a notice.
Yes, my lord. Notice subsequently, my lord, my premises have been locked.
Lordship, closure notice at page number 34.
34. He submits that though the petitioner has been diligent in approaching authorities for renewal, however, where at page 34?
My lord, Annex 12, page 34.
However, instead, he was served with a closure notice on 8 July 2024 for non-possession of a trading license. So,
The initially, my lord, first notice was issued on 4th July 23. Thereafter, after a year, we have been called to the office. We went to the office, my lord. They've been assuring that it will be done, it will be done. Then again, my lord, after a year.
Some, however. Of renewal of a state license. However, stop. However, not however, stop. Cancel the however. Cancel the however. Instead, first on 4th July.
Yes, my lord. 4th July 23. Then after a year, my lord.
And though he had approached authorities again, has been served with a second closure notice.
8th July 24, my lord.
8/7/2024. And 2nd August.
2nd August, my lord, closure notice.
So 2nd August 2024. He prays that as the situation is not of his own making, some interim protection be given to allow him to run his business. What do you have to say?
Lordship, I'm first the Lordship.
Lordship.
It's at page
Lordship,
13, my lord.
as of right now, I don't have any instructions yet, Lordship.
You have nothing to do also.
Lordship, the prayers against the
Mr. H. Long appearing first 101 submits as just a formal party and as such has no submissions to make. Stop next paragraph. It is noted that the petitioner has stated that notice has been served, but today there is no appearance on behalf of respondent 3.5. On hearing the counsel and further on perusal of the annexures annexed to the petition showing the fact that the petitioner had approached the respondent authorities, it is seen that at this stage some protection is necessary. Was issued in your name?
To us, my lord.
No, we're not. Was issued in your name?
To us, my lord.
No, we're not bothered about that.
Yes, my lord.
The thing is that you have not said anything about the locks. Where is said about the locks?
My lord, we have stated here.
Where? We have said that closure has been given and locks,
Yes,
and
sir.
that
Stated, my
the
lord.
respondent placed locks on your shop.
My lord, may kindly come to page 9. Para 14, my lord. If you
Where?
read it.
Where that you've locked the shop?
Yes, my lord. Para 14 says, my lord, 30 days time. Then, my lord, para 15. That the petitioner says that the petitioner, while he was... Yes, my lord. Here, the shop premise on 30/9/2024 at around 1:30 p.m. and sealed the business premises illegally and handed over the seizure.
Notice, you should submit that, no?
My apology, my lord.
You expect me to read all the petition line by line and...
my apology, my lord.
If you don't interim orders, that's your bad luck then. We'll just post it again another date.
My apology, my lord.
No, before that. On that closure notice, second closure notice. And another closure notice dated? Yes. He further submits that in the meanwhile, on 30/9/2024, at around 1:30 p.m., the respondents to the officers have sealed the business premises of the petitioner. Stop. Anta he therefore one. Of his own, yes, of his own making, yes.
Some protection be given and he be allowed to run the business.
Some to, yes, be allowed to run the business, yes, stop. Puli, the next what having heard some, sir? Some protections necessary at this stage, Puli?
It is noted that the petitioner has stated that the notice has been served, but is not arranged in the way of responsibility for 5D when hearing the
Today, stop. Yes.
when hearing the counsel on perusal of the annex
And on perusal of the annexures.
annex to the petition, showing that the fact that the petitioner has approved the respondent authorities is seen at least some interim orders is necessary to be given to the petitioner.
Some interim orders are necessary at this stage, yes. Or to, yes.
Accordingly, until the next date, the closure notice dated
Those two regions shall stand suspended. But then they'll have to come remove the seal themselves.
Yes, ma'am.
And the respondent 3, 4, and 5 directed to remove the seals forthwith and allow the petitioner to conduct his business. Stop. Next paragraph. As the order has been passed in the absence of a set count to 315, the liberty to file modification, alteration, or vacation of this order, if so advised. Stop. Just after 2 weeks. Stop. Copy of the order should be presented before the said authorities within a period of 2 days by the petitioner. Yes.
Deputy Major.
Why you're not giving enough masala to them?
Hearing. Item 23.
May please, Your Lordship.
Still, the matter is disposed of Supreme Court.
Lordship, I'm entering my appearance today. I'm yet to familiarize myself fully with
The
the...
matter is pending before the Supreme Court.
I-
Similar thing on all the benefits and all.
I believe
Never
so.
bearing on this case.
So if Lordship is kind enough to post this matter after a week, I'll take proper
We'll
instructions.
take it after vacations.
Let it come
Because
after a
nothing
week.
happened in
Because we are yet to enter appearance
Mr. S. Jindal has entered appearance today.
on behalf of the
On behalf of the petitioner. And prays that the matter be listed after 2 weeks to enable him to familiarize, the, no need to write that. Within 2 weeks, yes. However, counsel for the respondents, Mr. H. Karwanlang, for 1, 3, 4, 6, and 7, and Dr. Mozika for 2. Submit this as a matter is still post Supreme Court. Let the case be adjourned after vacations. Yes. Accordingly, we'll list the matter after first week on reopening.
Lordship, my small instruction was that I'd received was that the Supreme Court matter is not connected at all with this matter. The issues are completely different. So if Lordship would kindly take it after 2 weeks, if that is indeed the case, I will convince this honourable court, because the pendency of the matter in the Supreme Court, I've been told, should not be above for this honourable court to adjudicate today's matter.
What's the matter Supreme Court about?
If Lordship allows a week's time, I'll come back better prepared.
To Trump himself, yes, with the case. Stop. Less than this after 2 weeks, yes.
Highly pleasure.
That's great.
32.
Who's appearing, Mr. Karwanlang?
Lordship, the Advocate General will be appearing.
Where is he?
Lordship, he's coming, Lordship.
May it please, Your Lordship. Lordship is aware that this case relates to the encounter which happened on 13/8/2021, where the brother of the petitioner here was shot by the police. Now, the petitioner in this case, my lord, is staying opposite to the house of the deceased. Just directly of the deceased. They're brothers. And he could actually see what happened on the date of the...
But that's been gone in inquiry.
Yes. In fact, no, I'm just...
What about updated status report?
That we are not aware.
Mr. Call Advocate General, because he said that
Yes.
first let us see the updated status report, then, you know, and thereafter he may be allowed, the matter may be argued. Where is he? What status report?
Well, my lord, the most important observations by the inquiry is at page 47.
Page?
47. 47 onwards.
Yes.
Para 32, my lord. There is another aspect of the matter which cannot be lost sight of. It is an admitted position of the state witnesses that the deceased, at the time of the operation, was staying with his wife and his sons in the house. The state witnesses had cordoned off the building of the deceased. After shouting at the deceased, calling upon him to come out of his house for 3-4 times, and after waiting for 4-5 minutes to wait for the response, they broke the door open and forcibly entered the house of the deceased. Since civilians like the wife and sons of the deceased were admittedly present inside the house at the time of operation, prudence would have demanded that they should wait for the dawn to ensure the safety of these civilians, which should have been the paramount consideration while raiding a residential house in urban areas. Alternatively, the team could have lobbed in tear gas grenade inside the building so as to force the occupants to come out of the building. No such attempt was ever made. This issue also never came up for consideration in the tactical meeting. Of course, it is another matter that there was fortunately no civilian casualty in the course of the raid, but this cannot be a post facto excuse to justify the night raid. The common thread of evidence running through the statements of these state witnesses is that the objective of the operation was professed to be simply to capture the deceased alive and not to shoot him. This was the decision taken in the tactical meeting held prior to the operation. In my considered view, the operation was a well-laid plan but executed poorly, recklessly, hastily, and without proper application of mind. In other words, it was a botched-up operation and failing in its objective of apprehending the deceased alive, who could have given valuable information to the police about the subservice activities of the prescribed HNLC outfit. The fact that by undertaking such reckless operation, the team completely lost sight of the possibility of harming the family members of the deceased, who were never accused of having anything to do with the nefarious activities of the deceased he was charged of. If the primary objective of carrying out the operation was to capture the deceased alive, the manner in which the raid was conducted unnecessarily gave rise to the impression that that was not so. This is most unfortunate. Now, coming now to the killing of the deceased. The evidence now, the inquiry has used the word killing. The evidence of the state witness number 4 is that in the meeting, tactical meeting held prior to the operation, there were no talks regarding the intelligence information as to who were present with the deceased at his house on that night. When they reached the gate of the residence of the deceased, they called out to him 2-3 times to make the presence felt, but there was no response from the deceased or his family members. It was drizzling at the time of the operation, but it was not a heavy shower. On reaching the main door of the first floor, they knocked at the door 3 times, but there was no response, and forcibly opened the door. According to the state witness number 4, they were instructed during their training that having a torch in the corridor of a dwelling house in the course of operation against militant outfits would not have helped, as that would have only helped them to target them, and also that a torch was not necessary in a house arrest. He stated that after the team forcibly opened the door outward, he was first to enter the narrow corridor, which is approximately...
No, what is not important for us.
Yeah.
Yes.
Yes. We'll come to 34. In my opinion, having entered what could potentially be a lion's den in darkness without proper planning and without taking adequate precaution, state witness number 4 had taken purely avoidable and unnecessary risks, endangering his own life and that of the deceased, whom the team professed to have not intended to kill him in the first place. In my opinion, the forced entry into the house of the deceased in darkness and the subsequent killing of the deceased was a reckless exercise and tantamount to disproportionate use of force, which resulted in the death of the deceased. This apparently defeated the very purpose of launching the operation, namely to capture him alive. The deceased was never apprehended alive. It was thus a futile exercise. Had they waited for about 2 hours or so to let the daylight to emerge, cordon of the house of the deceased, as they actually did in here. In the meantime...
So therefore my finding that tactical team 1, yes, okay.
Yeah.
So
In my
the
consideration...
finding was that it was a culpable, thoughtless excessive use of force. Yes.
So the finding, my lord, I'll just read the 35. Both the learned counsel appearing for so. I do not propose to discuss the other evidence available on record to determine as to whether witness number 4 mouthed down the deceased intentionally or in self-defense, since the materials I could derive from the statements of 3 state witnesses are sufficient for me To arrive at my above findings about the culpability of the tactical team in the manner in which they carried out the operation, the remaining issues are best left to the jurisdiction of the criminal courts to decide. Now what has happened here, my lord? We have filed a FIR. The son has filed an FIR, consequent upon the, I mean, even prior to the inquiry report. But according to the petitioner, nothing has been done by the police. Now, Lordship will see the affidavit filed by the state also. They have not denied. In fact, it's a very vague affidavit. Their only contention is that we have taken remedial action consequent upon the report of the inquiry. Now, what has happened to the criminal case, my lord? Till date, we have not been informed. Let's para 4, 5, 6, 7, and 8 of the averments made in the petition have not been refuted by the state government at all. They've been silent.
What is 4, 5? What do you say? 4, 5, and 8.
That the petitioner states that he resides opposite the house, of course, of his deceased brother, and on the night of the incident, he woke up from his sleep on hearing loud banging door of his brother's house. The petitioner, on hearing the loud noise, got up from his bed and went to see from the window of his bedroom, which is just opposite to his brother's house, and saw that the lights in his brother's bedroom TV were on. Now what has happened? As soon as he heard, then he looked to his window and saw that the lights were on. Now, because this is what happened, my lord.
No, we're not on that.
Yeah.
Because
these are factual aspects.
It's over, right? The thing is that now the inquiry report is there. Whatever it is, the authorities will have to go by what has been the inquiry report to take appropriate action. That's all. As I see, now you're concerned in this writ petition, all you're concerned is the slow action of the police.
No, we say no action, not even slow. We're saying no action. In fact, the persons who were involved in the tactical team, they have been promoted instead of being prosecuted. We filed an additional affidavit to that effect also. They have not answered.
No, but the thing is that, see, being promoted or being demoted, that is
well,
a different aspect.
A different
but the
aspect.
Thing is that, yes. Now regarding the, only thing is that if the state is only to take, it's like culpability, excessive use of force. Now, what corrective measures are taken in such cases? I mean, if there's excessive force, it's a term which is, what is excessive force?
Here, my lord, the inquiry has said that.
But the inquiry has just said
it's beyond reasonable doubt
of the tactical team to excessive use of force.
Yes.
But they have not.
Short of calling it a murder, that's what he said. He's been killed. That's what the inquiry said.
No, very unfortunate. Whatever life is lost, life is lost.
Yes.
Whoever
he is, the Supreme Court is very clear on that. It doesn't matter if he is a terrorist.
Doesn't matter, but the manner is the. Anyway, Mr. Alfizi, what is the status?
Yes, my lord. Lordship, there are two submissions which have been advanced by London Senior Counsel, my lord. One with regard to relying on certain paragraphs of the Inquiry Commission report, saying that it was a kind of reckless exercise, etc.
Excessive use of force.
Excessive use of force. That the appropriate term is used, my lord. Kindly, I just wanted to show 2-3 paragraphs of the Inquiry Commission report, my lord.
Yes.
Kindly see paragraph.
You have placed paras 34, 35.
Yes, my lord. Kindly, before that, my lord, kindly see paragraph 19 and 20. Yeah. Paragraph 7, your lordship will see page 34. The breakthrough in the extortion case came on the complaint of one. Paragraph page 34, paragraph 17, my lord.
No. Oh. Sorry. Yes.
The breakthrough in the extortion case came on the complaint of one whose name was withheld by the police, who approached the police confidently on 2nd August 2001 with similar allegation as detailed earlier regarding demand notes received by him on 15 July 21 from HNLC. The investigating team was given an audio recording of the extortionist, and upon analysis of voice of the extortionist and comparing the same against control sample derived from the public available audio recording and video address of the deceased, it gave rise to suspicion of investigating officer of Clariat IED explosion case that the caller and the deceased were one and the same person. The audio sample was seized and sent for forensic examination on 2nd August 2021. Thus, the police came to draw the following inference: that was being used by Sanbar Pala to instruct accused person in IED explosion, but was being used by same Sanbar Pala to make extortion demand on behalf of HNLC. Audio of Sanbar Pala recorded prima facie matched that of deceased. My lord, kindly mark this line. Audio of Sanbar Pala recorded the deceased had been found by clinching evidence to have delivered money to a known accused in Clariat IED explosion on 14 July 2021. It was on the basis of the aforesaid material, the police started carrying out surveillance of the deceased with a view to identify opportune moments for his arrest, along with necessary incrementing evidence which would assist in bringing down the underground cadre of HNLC as well. During the period of such surveillance, an IED explosion was again carried on 10th August 2021 at Laimukra, which indicated the serious threat of HNLC. Thereafter, specific and confirmed inputs were received on 11th August 2021 and 12th August 2021, giving warning of possibility of another explosion of Punjabi Lane, Secretariat, Bada Bazar, etc. in Shillong. As already noticed, the investigation of Clariat IED explosion case has revealed the possibility of second IED remaining with HNLC cadre, which further fortified the possibility of IED blast. It was under these circumstances mentioned above, coupled with the other inputs so received, that on 12th August 2021 convened a high-level meeting of all top officials of police department, including officers involved in investigation and collection of evidence in the police headquarters meeting. The evidence collected so far were evaluated in threadbare manner, which left no iota of doubt as to active involvement of the deceased in illegal activities of HNLC and possibility of another IED explosion on 13 to 15 August 2021, which was considered to be looming large. It was under the aforesaid circumstances a decision was taken by the DGP Meghalaya to arrest the deceased expeditiously and without giving any opportunity to him to either abscond or destroy critical evidence which are necessary to establish his culpability in Clariat IED explosion case and other offences committed by him. Examination in chief by affidavit. My lord, paragraph 19. It may also be relevant to refer the examination chief who headed the special investigation team of Clariat bomb blast, who has examined the state witness number 2, which was constituted on 14 July 2021 to investigate the Clariat IED explosion. According to him, it was also important to identify Sanbar Pala, as it was clear from the arrested persons in connection with Clariat PS case number so and so that it was who instructed them to conduct IED explosion. At that point, the role of deceased had been established, but SIT was hopeful that he would lead SIT to Sanbar Pala, and his continued surveillance was therefore considered necessary. In July 2021, multiple reports started to emerge regarding service of extortion demands by HNLC to various persons, including high dignitaries and prominent businessmen, through Bangladesh phone number, were called and threatened to kill them or their family members if the demand for money was not met. Although such information had been received in confidence, however, the complainants were reluctant at the same time to file formal complaints since there was serious threat to their life. The recorded audio received, wherein the latter received from Sanbar Pala a call from Bangladeshi phone number, was seized in Clariat explosion case around 7th August 2021 when audio was compared again with the control sample of the deceased obtained from publicly available audio recording, and same was played to various sources who knew and were aware of the voices of deceased. It became clear that investigations that the voice of the recording was of deceased. Therefore, on 7th August 2021, it became clear that for the first time, SIT man behind IED blast under the investigation and all extortion demand is none other than deceased operating under the alias of Sanbar Pala using same Bangladeshi phone number, and there was a strong possibility of deceased operating under pseudonym of Sanbar Pala after coming overground by purportedly retiring from HNLC activities. According to witness, the above conclusion was fortified by the fact that HNLC publicly claimed responsibility for extortion demand in that period. It was also strongly suspected based on the above material that deceased was involved in Claridge PS case. The same was conveyed to senior official. In the meantime, another IED explosion occurred on 11th August at around 1:30 p.m. and the General Secretary HNLC claimed responsibility of said explosion, whereafter another SIT was constituted. On 12th August 2020, a confirmed intelligence input was received from multiple sources including intelligence agency, police headquarters and a special branch, whereby it came to the knowledge that there was a possibility of bomb explosion at Police Bazaar police area on 13th August. This intelligence input matched with the disclosure of one of the accused Claridge case that there was a possibility of another bomb. It was on 12th August 2021, 8:30, it was asked to immediately come to SP office and decision to cause arrest of deceased had been taken. There is no reason to cast doubt on the statement in respect of above information. In any case, learned senior counsel also does not raise any issue on the aspect of the matter. So far as investigation and decision to arrest my lord, there is no dispute that there is no opposition, and the material has also not been doubted by the learned senior counsel representing the relative of the deceased, my lord.
That's fine, that's fine.
Now,
regarding only the...
Regarding, my lord, that...
It's confined a very small...
yes, my lord. I will...
Orders can be passed, so we don't know whether...
Yes, my lord. I will address that part also, my lord.
The prayer says to hand over to CBI.
Yes, my lord. I will just deal with that aspect also, my lord. One aspect in clear, my lord, that the action of the commission has returned the finding that the action of the police to effect arrest him is a bona fide decision, and for that the decision has been taken. So to that aspect, my lord, there is no malified decision, and there are ample material on the record, and it has come before the commission of inquiry that the decision was a bona fide decision, and the police officers in discharge of their duties, they went to arrest him, my lord. Now kindly see what there are findings which are, in my humble submission, my lord, are contrary to certain discussions which have taken place by the commission only. Your lordship will see that part also, my lord. So then I have to show that it was a bona fide decision, my lord. Kindly see paragraph 22.
Yes.
Because decision is correct to arrest him. The decision was also upheld, that decision to effect arrest was also correct, my lord. 22. According to this witness, and that aspect of the matter, my lord, has not been disputed by the petitioner, my lord. According to this witness, his team reached the residence of the deceased at about 2:55 a.m. It was raining on the night of the operation. On reaching the location, team made their presence known and called the deceased to come out. In his examination by learned counsel for commission, he stated that everyone who was a part of the operation team was categorically briefed by the officers heading the team, and their duties and operation was specifically to arrest the deceased. In the tactical meeting, it was held before the operation, the possibility of presence of militant IED attack, grenade attack was discussed, and later all the teams were briefed about the threat perception. He could not remember with the certainty whether specifically in briefing possible attack by deceased was discussed. He admitted at the tactical briefing that they received no intelligent input about the presence of armed militant at house. He, however, stated the possibility of their presence could not be ruled out, which was also discussed briefly in the briefing meeting. After raid was conducted, it was found that on the floor where deceased was staying, two persons whom they came to know later as his sons were also residing. On the ground floor, his wife and other family members were present. There was no militant at the house of the deceased during the time. He, however, at the same breath claimed that there was no information regarding given to that deceased was only with his family member. To the 23, the state witness 22 also stated the operation the officers were carrying pistol, etc. My lord. He, however, stated he could not say whether police department was having night vision, my lord. The discussion, the various issues were discussed, my lord. And then, my lord, regarding the operation, that is the tactical member, my lord, because tactical member was the main issue. Is lordship will see that a discussion is there at the bottom of the page 40, my lord. Or, my lord, kindly permit me to place page 40, paragraph 24, my lord. Then took me to the evidence of state witness number 4, paragraph 24 at page 40, my lord. Then they took me to the evidence of state witness number 4, who sought at the deceased, my lord. According to him, On 12th August 2021 at 11 p.m. he was present in the office of SP. In the meeting, the briefing was deceased was to be arrested, my lord. Interrogation, there was no instruction to shoot the deceased, but they were briefed that they should be careful and take precaution in alert as he might be having arms, explosive, and there could be other members of HLC. They were also briefed in the meeting that if there was any attack, the response to the attack by him was to capture him alive. The weapon he carried on the day was AK-47. Operation of arrest was conducted at night, but no night vision was or torchlight was provided to him. The witness further testified that according to his knowledge, there is no night vision or goggle available to police in Shillong, but it was supplied to police in Garo Hills district. According to the training given to him in an arrest conducted at a house, there was no necessity of night vision goggle. In his opinion, even on the night, provision of night vision goggle would not have been helped them in any way, since NVD would only disturb their eyesight and NVD could help only for long range vision in the jungle in the night. In the meeting, there was no talks regarding intelligence information as to present the deceased at his house. When they reached the gate of the residence of the deceased, they called to him 2-3 times. My lord, kindly mark 2-3 times. To make the presence, but there was no response of the deceased or his family member. It was drizzling, but it was heavy shower. On reaching the main door of the first, we knocked the 3 times, but there was no response, and forcefully opened the door. Having a torch in the corridor of residence of the deceased would not have helped, as there is training. They were instructed that the having torch and underground operation would have helped in so and so. He stated that he was at first entered into the new narrow corridor, which is approximately 3 feet wide, and their team members forcibly opened the door. Corridor was completely dark. He had proceeded further into corridor, almost reached the end of corridor, when suddenly in the cover of darkness, one person came charging towards him, aggressively making a loud noise. It had appeared to him that darkness that his hand was raised and was about to attack him, whereupon witness shouted "Sange, Sange." When the person did not stop and continued to charge aggressively, when the distance between him and aggressor was barely 2-3 feet, fearing imminent attack by the aggressor for his life, he was left with no option to save his life in self-defense. In a split-second decision, fired one round from his service weapon at the lower portion of the aggressor. The person sustained a bullet injury and collapsed. The other members of tactical were behind him. Thereafter followed by another senior. A knife was also found, etc. So, my lord, what is...
He was killed by a single shot.
A single shot, my lord. Single shot, and that too on lower, my lord.
According to them, lower portion and self-defense. My lord, the post-mortem report which I've also annexed would show that he was shot sideways. He was not shot.
I will show that part also.
No, but this is important.
In the darkness, you don't know. He'll jump here and there. You don't know.
No, but the thing is that according to them, the first reaction from the police also that we had to kill him in self-defense.
No, but one fact remains: he was not shot in the head or.
They say lower portion. He was
also region, no.
No,
he was shot in lower portion.
In the stomach.
Okay.
He was shot on the right and came out from the left. So their version that he came and attacked me also falls flat on the face of it.
No, that will not go into that, because the thing is that we cannot.
Yes, the inquiry has gone into
because
that.
The thing inquiry has gone to it. Yes. But the thing is that only finding is maybe there's excessive use force, because the mission objective was to
capture,
apprehend, and
capture.
arrest the deceased. Yes. No, that's the thing. Yes. So now, what is there for this court to do, Mr. Dingo? What do you want?
The only thing I want is that it should go to an independent investigation.
But this is quite detailed, and witnesses have been examined. Everything.
That's why the inquiry also has said.
Which independent agency you wanted to go to?
That is CBI only, because these are the police force involved.
My lord,
there's no other agency. Where else can it go?
No, because on the circumstances of the case, I'm not saying like it's what do you call it, an encounter where just bodies were found or something like that. It's not that. It's a question of, and one single bullet.
Yes.
That is also beside the point when sitting here. Only thing is that whether, yes, Mr. Apkin, where's the status report on the...
Yes, my lord, that status report is, my lord, the report is there, my lord. But
that's why, my lord, the inquiry, the officer also
the inquiry is quite detailed.
Very detailed.
But he said each and every aspect has been taken care, my lord.
The only thing is that what they're coming for is maybe only on the slow you know,
we will expedite, because the fact of the matter is, my lord, two things are very well established. There is no dispute.
let them complete, Mr. John, you're not satisfied. Not his arguments.
Yes.
Let them complete whatever the investigation, and if you're not satisfied, then that time maybe what the findings, because now we don't know what kind of investigation. That's the only thing.
Yes, my lord.
And at a stage to refer also.
Yes, my lord. Because the parameters for there two facts are not in dispute between the parties. One, the operation was bona fide, and secondly, the death has taken place in the single shot. These two facts are not disputed, my lord. Now, what
The
this
only aspect we examined,
yes, my lord,
is like whether in the exercise or in the what you call implementation or on the execution of the operation.
Yes, my lord.
Whether excessive force.
Yes, my lord.
Can be, like inquiry said, yes, the culprit excessive force.
Yes, my lord. So,
but then inquiry also is not an expert to say that whether.
Yes, and night vision in close counter, my lord. When there is a heightened, ultimately, my lord, when the officers are going with all these inputs and material, if there is an excessive, assuming that state is at fault or the officer is excessive, what my friend is required to, so because there are certain protections which are available to the police officials, my lord, because then
we were well aware, even the senior counsel would
yes,
appear in this encounter,
yes, my lord,
encounter matters also,
yes,
in many questions
where
3-4 people have been gunned down during
no,
the
that
operations.
is in
we
the
have,
MBOC.
like, we were counsels there
my
also.
lord, in fact, I was the lawyer when I filed a PIL in that MBOC matter, and Justice Chalmeswar issued in my PIL. My lord, that I have seen. That was so clear. That was a gross case.
Before that was happened here in Shillong. That
yes,
time,
my lord, that was
where the bodies were there on the roof and this
yes,
and that.
My lord, that was a gross case. I remember Justice.
It's not a gross case. I mean, we were defending the police.
We sailed through. That's so. I was representing at that time, point of time, victims. I was representing victims in those cases, my lord. So to my submission, my lord, this case is completely distinct, my lord. What I say is that ultimately when the situation warrant, because the intention at no point of time, my lord, your lordship I can place the evidence of each and every witnesses, my lord. They have been put to cross-examination by my friend.
So today the court's well aware of what are the the parameters.
Parameters.
We are taking this case.
Yes, my
Now,
lord.
let's see the
Yes, my lord. We will direction can be issued to expedite the, my lord.
Because according to what, let them, if they don't come to any, because
What we say, even if they expedite, how can they expedite against their own person?
Because the question is, my lord, simply in all the cases, what they say that police cannot investigate.
What this is, this AK is 7.62 mm AK.
Yes. That is in the.
And what has happened, my lord, that bullet shot hit his spleen, my lord. That lower, and he was having the pre-existing medical condition also. The disease was having, and therefore there was no intention whatsoever. In fact,
did the inquiry report go into the aspect of whether the injury inflicted upon him would have led to his death, or maybe because of his preconditions led to his death? Or
that aspect is also discussed in the inquiry. That aspect.
Whether in a normal course.
No, in fact, no. The inquiry said I need not go into all that aspect. I mean, the
intention. See, if you look at intention,
because the mens rea is important.
Excessive force.
Yes.
Intention. That's very important. Like now, intention. If you want to kill, that means you shoot. Point blank in the head.
Point blank.
It's like that.
Yes.
So that means that's excessive force intention. But in this case, if excessive force can be said, so you shoot torso in the dark.
Because what this witness has said, he said I aimed in the lower part of the body. I can understand if it is in the foot.
Because they were in corridors.
But it was not
they were in corridors,
Close compartment.
They were corridors, my lord. But
what is this? What is this, Mr. Affidavit?
This is the, my lord, the status report, my lord, up to 14th this November report is, my lord. So if your lordship will kindly see page 6, my lord.
You kindly give a copy to them also.
Your lordship, because the names etc. of the tactical members are also there, my lord. That is all.
The names of the
and because they are all from that locality. Don't record because
additional affidavit to say that the person
and they are all
who led the team has been promoted.
My lord, they are from the same locality also.
From where is staying?
So that those are the. And at least if the exercise, my lord, is, your lordship, in my humble submission, exercise is bona fide based on the material, my lord, then the scope of CBI inquiry, my lord, I have got those authorities of the Honorable Supreme Court that the scope of CBI inquiry is not there, my lord. What my friend is saying, that the exercise was bona fide. All family members came out except except the deceased, my lord.
It happened 21, this incident.
Yes, my lord, 21.
21. 13/8/21. 13/8/21.
Kindly see one paragraph, my lord, page 30, paragraph 10, where page 30 of the report, my lord, where the Commission of Inquiry.
No, it's okay.
Paragraph 10, my lord.
Now you can say that you collected all the
Materials, my lord.
everything from.
Yes, every investigation to that extent, collection of evidence and material is almost complete. What I gather from the reading of the latest status report.
Quite detailed also. The
Quite
collection
detailed
of
also.
material.
You know, it's not that. And parameters, my lord, if I can place the authorities, my lord, on this issue.
Yes.
Parameters, my lord. I've got the here. This is the bench. No? If my lordship will
No,
see.
the only grievance is this, that that if I read it correctly, is that since the commission has come to a finding excessive use, so the person who did the act should be punished as well.
No, my lord,
That's the only thing they want.
this is what they are. Your lordship is absolutely correct.
Not only that, my lord, but what made him do it also. This is more than. It's not that he did it, no doubt.
Because he's saying, admitting, my lord. He's admitting, my lord. See, in any investigation, this is the only thing which will come out, my lord.
No, because from the facts, if it is it is a
Single shot.
barrage of shots from there,
And-
I would have,
And Commission of Inquiry is also saying that the operation was correct.
To kill, to shot more than once.
And then they could have done it anywhere, my lord. They could have. They could
He's
have.
an expert and he knows where to shoot. That
no,
also. The main issue here is whether the police themselves can investigate this case. I mean,
My lord, I have the authorities where the Honorable Supreme Court says police can do it. That those authorities, if I can place, my lord. But before that, my lord, kindly see page 30. Page 30,
we will
paragraph
place
10.
our authorities also, my lord. We will also place our authorities.
Page 30, my lord, paragraph 10, my lord.
No, this court can't give a finding over and
Yes,
above
my lord,
the
because
entire
that is
report.
subject.
You will see-
we're not
This
asking that.
only thing which your lordship would be required to see is the parameters for referring these matters to the page 30 of the petition, my lord, paragraph 10, my lord.
Yes.
I have perused the statement dated 20 so and so, accompanied by copies of 30 documents backed by affidavit, which was given in response to notice dated so and so, my lord. And was examined state witness. Learned senior counsel for the first party requested cross-examination, which was opposed by so and so. Commission agreed with the submission. Now, my lord, kindly see thereafter. I am of the view that based on various intelligence reports, the decision taken by Meghalaya police to apprehend the deceased or to conduct raid at the residence of deceased cannot be faulted. Your lordship may kindly mark this line, cannot be faulted and is therefore justifiable. Apart from his alleged involvement in criminal activities, subversive activities, extortion racket, for which more than 82 criminal cases of the offences of murder, kidnapping, ransom, violation of Arms Act, escape from law were registered against him at various police stations, the following sum based on intelligence had apparently prompted Meghalaya police to cause arrest to the deceased, my lord. So the action, my lord, if there was intention to gun this person down, my lord, the commission is saying that decision to arrest, apprehend and to conduct raids is now circumstances which my friend is saying. They are also not disputing that the person died because of single shot injury in the darkness at that point of time when it was drizzling, my lord. Assuming everything is correct, my lord, whatever my friend is saying, whether all these kind of cases would entail CBI inquiry, my lord, kindly see the parameters which, my lord, have been set down, my lord. First, the leading judgment is the constitution bench judgment on this issue, and your lordship will kindly come to page 53, where the 53 at paragraph 70 of the compilation, my lord.
At page that's
Sorry, page, same page, no?
Tangaraj.
Yes, my lord, page 53 of the compilation, and yes, my lord. Yes, page 53, my lord. This is the judgment of State of West Bengal versus. It starts from page 22, but the relevant parameters with regard to exercise of, my lord, because this is a constitution being judgment, and in final analysis, our answer to question referred is that direction by the High Court in exercise of paragraph 69 at page 53, my lord, I am reading. In the final analysis, our answer to the question referred is that direction by the High Court in exercise of jurisdiction under Article 226 of the Constitution to CBI to investigate a cognizable offence alleged to have committed within the territory of state without the consent of state will neither impinge upon federal structure of the Constitution nor violate the doctrine of separation of power and shall be valid in law. Being the protectors of civil liberties of citizens, this court and the High Court have only the power and jurisdiction but also obligation to protect the fundamental rights guaranteed. So your lordship's power has been recognized that your lordship can pass the direction for instituting CBI investigation even without the consent of the state government, because under section 6 of the Delhi Police Establishment Act, requirement is that the consent of the state government is required. So that was the constitutional issue raised in this matter, my lord, and then it was answered saying that this court has the power to do it. Now, my lord, 70. Before parting with this case, we deem it necessary to emphasize that despite with wide powers conferred under Article 32 and 226 of the Constitution, while passing an order, the court must bear in mind certain self-imposed limitations on the exercise of these constitutional powers. The very plenitude of the power under the said article requires great caution in its exercise, insofar as the question of issuing direction to CBI to conduct investigation in a case concerned, although no inflexible guideline can be laid down to decide whether or not such power should be exercised, but time and again it has been reiterated that such power and such an order is not to be passed as a matter of routine or merely because a party has levelled some allegation against the local police, my lord. The extraordinary power must be exercised sparingly, cautiously, and in exceptional situations where it becomes necessary to provide credibility and instill confidence in investigation, or whether the incident may have national and international ramifications, and where such an order may be necessary doing complete justice and enforcing the fundamental right. Otherwise, CBI would be flooded with large number of cases with limited resources, may find it difficult to properly investigate even serious cases, in the process lose credibility and purpose with the unsatisfactory investigation. 71, my lord, is also I am relying. In minor irrigation and rural engineering services, UP versus Sahangu Ram Arrear, this court had said that an order directing an inquiry by CBI should be passed only when High Court, after considering the material on record, comes to the conclusion that such material does disclose a prima facie case calling for an investigation by CBI or any other similar agency. We respectfully concur with these observations. My lord, Constitution Bench has said that your lordships will have to record the finding, that prima facie finding, and my lord, I have shown the material before your lordship saying that the exercise was bona fide, the exercise was carried out in the darkness, exercise was a kind of, there was no deliberate or willful conduct on the part of the parties, my lord, to cause unwarranted death of a person, be it a person who is involved in so many cases, my lord. Kindly see, my lord, the other judgment which I am referred in this, the lordship serial number 2 is Secretary Minor Irrigation and Rural Engineering Service versus Sahangu Ram, my lord, and paragraph 5 and 6 at page 10 of the compilation, my lord.
Yes.
5, my lord. While none can dispute the power of the High Court under Article 226 to direct an inquiry by CBI, said power can be exercised only in cases where there is sufficient material to come to a prima facie conclusion that there is a need for such inquiry. It is not sufficient to have such material in the pleading. On the contrary, if it is not sufficient to have such material in the pleadings, on the contrary, there is a need for the High Court, on consideration of such pleadings, to come to the conclusion that material before it is sufficient to direct such an inquiry by CBI. This is the requirement which is clearly deductible from the judgment of this court in the case of common cause. This court in the said judgment, paragraph 174 of the report. Thus, other directions, namely direction to CBI to investigate any other offence, is wholly erroneous and cannot be sustained. Obviously, direction for investigation can be given only if the offence is prima facie found to have been committed or person's involvement is prima facie established, but a direction to CBI to investigate where a person has committed an offence or not cannot be legally given. Such a direction would contrary to concept of philosophy of life and liberty granted to a person under Article 21 of the Constitution. This direction is completely negation of various decisions of the court, in which concept of life has been explained in a manner which infused life into letters of Article 21. Paragraph 6, my lord, it is seen from the above decision of this court that right to life under Article 21 includes right of a person to live without being hounded by police or CBI to find out whether he has committed any offence, or is an inquiry by CBI against a person can only be offence is in living as a law-abiding citizen. Therefore, it is clear that a decision to direct an inquiry by CBI against a person can only be done if the High Court, after considering the material on record, comes to the conclusion that such material does it disclose prima facie case calling for an investigation by CBI or any other similar agency, and the same cannot be done as a matter of routine or merely because party makes some such allegation. In the instant case, we see that High Court, without coming to a definite conclusion that there is a prima facie case established to direct an inquiry, has proceeded on the basis of ifs and buts and thought it appropriate that inquiries should be made by CBI. With respect, we think that this is not what is required by law as laid down in the common cause. My lord, this judgment, my lord, has been upheld, and lordship has seen in state of West Bengal, paragraph 70 particularly, upholding the parameters. My lord, here independent inquiry has also been conducted by Commission of Inquiry, giving full opportunities to every person, the public, including relatives of the deceased, my lord. And after inquiry, the Commission of Inquiry has held that it was a bona fide decision. Commission of Inquiry has said that there is some excessive use of force, but that will not call for, my lord, if there is your lordship is aware that there is certain protection which is available to police officials. If he is doing something in discharge of official duty, and, my lord, protection is under there 197 of CRPC, my lord, if excessive force is also there, that protection is also available to. What is required by my friend to show that it was a complete malified exercise, it was a deliberate exercise to carry out a killing of a person. Nothing has been pleaded, nothing has been shown, my lord. Recent judgment, my lord, kindly see on this point, my lord, at page 66 of the 2019 judgment, my lord, where the again page 66 and paragraph, my lord, paragraph 12 at page 70, my lord. The question as to whether High Court could direct CBI to take over investigation in the facts and present case needs to be examined. Constitution Bench in the state of West Bengal has examined the question as the right of CBI to investigate the criminal offence state without his consent. This court examined Schedule 7, entry so and so. It has held that legislative power of union to provide, my lord, that I have already shown, my lord, the summary of state of West Bengal judgment, my lord. 13, my lord, is the committee of the relevant extract from judgment read as Committee for Protection of Democratic Right. Then, my lord, paragraph 14, my lord, is two judge bench minor irrigation which I have already placed before your lordship, my lord. Paragraph 5 at page 15, my lord, extracted, and 6 is also extracted, which I have already placed, my lord. And then paragraph 16, my lord, is the approval of law in minor irrigation by the Constitution Bench in the state of West Bengal. And then 17, my lord, a 3-judge bench in Sujata Ravi Kiran versus State of Kerala held that extraordinary power of constitutional courts in directing CBI to conduct investigation in case must be exercised in rare in exceptional circumstances, especially when there is a lack of confidence in investigation or national interest. Court had held, taking into account law laid down by this court in Committee for Protection of Democratic Right, direction for investigation by CBI was declined by this court in so and so and so and so. Considering the fact and circumstances of the case, in the light of our principle, we are of the view that a case in hand does not entail direction for transferring the investigation from state police to police CBI. Facts and circumstances in which offence is alleged to have been committed can be better investigated by state police. However, having regard to nature leveled by petitioner, we deem it appropriate to direct the state to constitute a special team in the rank of so and so to investigate the matter. In another judgment, paragraph 18, R.V. Rajendran versus CBI, it was also held that the court could exercise constitutional power of transferring an investigation state investigation to the other independent agency only in rare and exceptional case. The court gave its instances as such as high official of state authorities are involved on the accusation itself is against top officials of investigating agency, allowing them to influence the investigation and instill confidence in the investigation, my lord. After capturing, my lord, the entire history, my lord, paragraph 22 is the conclusion in this judgment that we find that finding recorded by High Court that DT could not transfer its land in any case is not tenable. Appellant relies upon statutory provisions in support of its transfer of land. The sweeping remark of allegations are against the government and the board, which consists of government functionaries. Therefore, the matter requires investigation by CBI are wholly untenable, and such sweeping remarks against the government or board should not have been made.
Why reading?
I'm sorry, 22. Sorry, 21. I'm sorry, 21. I'm sorry, my lord, 21. Or, my lord, 22, your lordship may kindly, it may be kept in mind that police public order entry 1 and police entry 2 is a state subject falling under the list 2 of the Schedule 7 of the Constitution. It is a primary responsibility of the investigating agency of the state police to investigate all offences which are committed within the jurisdiction. Investigation can be entrusted to Central Bureau on satisfaction of condition as specified therein only in exceptional circumstances laid down in the state of West Bengal. Such power cannot and should not be exercised in a routine manner without examining the complexities, nature of offence, sometimes tardy progress in investigation involving high official of state. Now, my submission, my lord, is that there is an independent inquiry in this case which has gone into the entire matter in threadbare, my lord. No exceptional case is made out for handing over the investigation to the CBI. If your lordship will see the...
No, in the case they said that did they any direction for the police to do anything over and above what's found in the report? Any directions are there?
No,
any advisory? Does it contain advisory?
No, my lord, as per...
people who are, who are culpable of use excessive force may be dealt with by the department themselves. Is any
your lordship, the requirement is that the Commission of Inquiry Act, my lord, is a recommendatory body, which and that it says that action under the Commission of Inquiry report, my lord, action
takes assembly,
my lord. Your lordship is aware that it is placed in the assembly, my lord. Now, so therefore, my lord, having regard to the fact situation which we are having in hand, my lord, it's not a case where the petitioner has made out a case of...
Suppose it goes to CBI, are you in any way prejudiced?
No, my lord, the question is, my lord, your lordship has seen the judgment that I will be hounded again, my lord. I have done my job, my lord. We need some protection from the court also, because in such cases, my lord, if we have to carry out certain exercise and if I am hounded and the police officials, there will be the morale of the police officials will go down, my lord, because these are very difficult exercise which they have to carry out in the extreme situation, my lord. Your lordship has seen that the series of IED explosions have taken place. Materials are there which connects Sonbor Pala with the deceased, my lord. Materials are there, my lord. Under those circumstances, my lord, it's not the question of prejudice, my lord, it's question of protection which the officials have to examine, my lord. And therefore, my lord, in my humble submission, my lord, it's not a case, my lord, because if the extreme case also, my lord, that I have placed that Ghanshyam Upadhyay's order also, my lord, where the general allegation is there, my lord, that excessive, and that too the exercise or the operation which has been carried out by the police.
Any other case is similar to this case?
Your lordship will...
regarding where Commission inquiries...
Yes, my lord. First, if your lordship will see the first...
Pursuant to,
yes, your lordship.
Recommendations...
Page 1, your lordship will kindly see page 1 of the...
Because it's not a simple case where something's happened, we're asking CBI inquiry. It's a case of,
your lordship will kindly see page 1. And the
so this is
that Vikas, my lord.
For page 1 is for...
Page 1 is Ghanshyam Upadhyay versus State of Uttar Pradesh with against police prayer for replacing Commission of Inquiry constituted by state government with independent SIT constituted by Supreme Court on the basis of news without further there is no evidentiary value, my lord. And then your lordship will see paragraph 16. And this was rejected, my lord, because Commission of Inquiry was conducted, my lord. Saying that Commission of Inquiry cannot be replaced, my lord. And if your lordship kindly see the writ petition, kindly see the writ petition, my lord. Prayer, my lord.
No, prayer for...
Prayer, my lord, just...
for CBI inquiry.
CBI inquiry and material in support of that prayer also, my lord. Lordship will certainly take into consideration the material, my lord. If your lordship will see paragraph 10 onwards, my lord. The only material which my friend is relying upon is, my lord, that one stray observation that disproportionate use of force, my lord, is a single shot, my lord. And that will itself, my lord, assuming if the matter is handed over, ultimately we are admitting, my lord, that it was a single shot injury. Is it a case of exceptional circumstances where your lordship will return that And they are also not denying that it is a single shot, my lord. Petitioner said upon receipt of inquiry report, paragraph 12, my lord, on the same day he submitted letter to respondent demanding an independent investigation in the case, preferably of central. However, till date there has been no response by the government, my lord. Then 14, my lord. The petitioner stated the respondent has categorically stated that deceased had attacked the police team by using a knife. Petitioner during the course before the first who opened the fire was not sure whether deceased was holding a knife. Some of the state witnesses have stated a knife was found discarded, but some stated deceased so and so. My lord, so this is the all they have placed before your lordship for directing CBI inquiry. What I am trying to say is, my lord, they are not saying that the action was unwarranted, action was mollified, action was without any basis, my lord.
Yes.
So therefore, if there is nothing, my lord, why should I be hounded, my lord? Kindly consider this aspect in the mind, my lord, that these are very difficult exercise which is carried out by the police officials. And every encounter, my lord, there will be suspicion against the state police, my lord. And on suspicion and bias, my lord, matter in my humble submission cannot be referred to because those parameters are laid down very clearly, my lord. And in my counter affidavit, my lord, I have placed the basis also, my lord. If your lordship will kindly see. Findings in paragraph 20 at page 6 of my counter affidavit. Page 6, paragraph 20, my lord. That it is submitted that one man commission of inquiry under section 3 of the commission inquiry has written the finding in favor of police by recording the same as under. In my opinion, inputs received by Director General of Police or on the basis of fact of the case are sufficient for him to take a decision to arrest the deceased. After all, it is not necessary to establish beyond reasonable doubt, unlike a criminal tie, the deceased was definitely involved in a criminal activities he was charged with. This could definitely decide to they could definitely decide to arrest the deceased if, based on above inputs surrounding, has entertained reasonable ground for suspicion deceased was still involved in subversive activities even after he surrendered to the authorities, and he should be given an opportunity to abscond or he should not be given any opportunity to destroy. Because, my lord, it has also come, we were having this, we were tracking his phone number and he was changing the location. He was having two houses. And we were having the data also, my lord, to show that he was changing his location. There was another house also he used to stay with someone which we don't want to disclose, my lord. And then your lordship will see paragraph 22. So that was also not very certain because on the important conclusion report of the Commission on issue number 1, circumstances leading to the police action of 13th August, resulting in death of late so-and-so, Commission held that decision to arrest was fully justified, my lord. Stand of the government is fully vindicated finding of inquiry. Commission has evaluated the evidence and came to the conclusion arrest was fully. Commission has also affirmed the fact that decision of arrest was not knee-jerk or sudden but prolonged and professional investigation of criminal activities like ID explosion. Commission has also recorded the fact that even family members did not dispute the fact was proper, my lord. That it is submitted to Commission of Inquiry or operational issue also made certain. Commission inquiry in paragraph 32 has noted that operation was well planned, but Commission also held that it was executed badly, my lord. 32, the Commission has written that it was well laid down. However, it is submitted has also not had police tactical culpable or any manner. Certain suggestions have been given on the issue of similar operation in future. Commission inquiry after 8 months of detailed inquiry and after examining the police and public submitted on 19th the following to avoid or prevent recurrence of this here, the Commission may make the following: raiding of residential house occupied by civilians in urban nights in pursuit of criminal to arrest them should not be carried out so that innocent are not harmed, my lord. There, my lord, sometimes we have to carry because this, if this is accepted, my lord, that the criminals can hide in the urban area, my lord. Then police personnel deployed for night operations should be provided with night vision devices, my lord, because in close encounter NVD doesn't work, my lord.
Doesn't work.
It doesn't work, my lord. That is the close encounter, because it is for, and it is the report of the tactical team is also. Use of tear gas grenade should be made mandatory for security while raiding the residential house, my lord. That will have more casualty, my lord. Event of raiding such residential house, the primary concern should be avoid endangering life of innocent or to prevent avoidable collateral damages, my lord. Sensitization of police force to respect human rights, my lord. That any henceforth whatever any raid is being conducted, the ambulance should be made part of team, my lord. Sometimes we have to do coveted operations, my lord. If we carry out all those things in carrying out the raid ambulance, then everybody will be knowing that we are going with the. So those recommendations are very too general in nature, and there is no finding that it was a case where, my lord, it was a deliberate, mala fight, and the Commission of Inquiry has gone into each and every aspect of the matter, my lord. So in my humble submission, parameters laid down by the Honorable Supreme Court in the various judgment and in the facts of the case and on the basis of pleading, my lord, it is not a case of exceptional circumstances where your lordship will exercise extraordinary.
What happened when the report was placed before the assembly?
It was never placed, according to my.
Under the, my lord, the law on this issue is that they are all directory in nature, my lord, because ultimately.
Yeah, but was it placed before the assembly?
To my knowledge, my lord, also I don't, because I did not see anywhere in comments also, my lord, that it is placed before the committee, but I have to check that aspect of the matter, my lord.
No, but
usually it is.
Now it's already been made public. Usually before it is made public, is it before the assembly?
It is the property of the house, my lord.
Yes.
It is the
So
property
before,
of the.
you won't see the report.
In fact, RTI, there was a direction to give the report in RTI.
Because we didn't get a copy of the reports, we had to resort to RTI.
In RTI they handed over the report, my lord.
No, but then it should be placed assembly first before.
First
is
should
it
have been,
public?
yes,
Because
yes, your lordship is absolutely right on this.
Anyway, what was the procedure adopted here? It was not placed.
Because the action taken report, my lord, if your lordship will see, that part is also covered, my lord, in my counter affidavit.
No, I will go to the status report. I'll fix it today.
I am not privy to this status report, but if your lordship will just see one paragraph of my writ petition. We have cited para 22, whereas we have cited the Supreme Court judgment in PUCL. Let we'll find at page, what are the page 39 of my compilation.
Oh, you also have that secretary managing irrigation.
Yes, sir. Now, I'm allowed to come to page 59. In such cases, what is the mandate of the Supreme Court? Page 59, para 31.
Yes.
In the light of the above discussion and having regard to the directions issued by the Bombay High Court, guidelines issued by NHRC, suggestions of the appellant PUCL, amicus curiae, and the affidavits filed by the Union of India, the state government and Union territories, we think it appropriate to issue the following requirements to be followed in matters of investigating police encounters in the cases of death as the standard procedure for thorough, effective and independent investigation. 1. Whenever the police is in receipt of any intelligence or tip-off regarding criminal movements or activities pertaining to the commission of grave criminal offence, it shall be reduced into writing in some form or in some electronic form. Such recording need not reveal details of the suspect or the location to which the party is headed. If such intelligence or tip-off is received by a higher authority, the same may be noted in some form without revealing the details of the suspect or the location. My Lord, I'll pause here for a moment, because the case of the government is that the deceased was under surveillance. In fact, the inquiry report also indicate for 2 months. They knew his movements, not that they didn't know. So that has to be there. You have to keep a record. Whether that is a part of the...
They don't have that record.
They don't have. Now, my Lord, if pursuant to the tip-off or receipt of any intelligence as above, encounter takes place and firearm is used by the police, and as a result of that death occurs, an FIR to that effect shall be registered, and the same shall be forwarded to the court under section 157 of the Code of without any delay. While forwarding the report under Section 157 of the Code, the procedure prescribed under Section 158 of the Code shall be followed. Now, an independent investigation into the incident encounter shall be conducted by the CID or police team of another police station under the supervision of a senior officer at least a level above the head of the police party engaged in the encounter. The team conducting inquiry investigation shall at minimum seek to identify the victim, color photographs of the victim, so recover and preserve evidentiary material including blood stain, earth, hair, fibers, thread, etc. related to the death, to identify the scenes. So these are the directions. Well, as I said, I'm not privy to what they have filed.
Everything has been complied, my lord.
Now, a magistral inquiry under Section 176 of the Code must invariably be held in all cases of death which occur in the course of police firing, and a report thereof must be sent to the judicial magistrate having jurisdiction under Section 190 of the Code. The involvement of NHRC is not necessary unless there is serious doubt about independent and impartial investigation. However, the information of the incident without any delay must be sent to the State Human Rights Commission as the case may be. The injured criminal would be provided medical aid, so all this.
Everything has been followed, my lord.
No, my lord.
Everything has been followed. All these directions have been followed to the hilt.
Your lordship will see.
Do one thing, Mr. I'll just look at it, says report, we will fix it again. We'll conclude arguments. Yes. For the parties at length, this report has been submitted by the Advocate General today. This report dated 14/11/2024 has been filed by the Advocate General. Matters the same to peruse. Lists the matter for further hearing on.
Today's content. Today's 18.
Any day, whatever convenient to you, first week December.
First week December.
First week December.
33.
If we look at it in a detailed manner,
Yes,
because
yes.
a lot of materials
Are there facts are
a lot of materials have been collected from all different source statements and
My lord will see one thing, because the first response of the police department of the state is that they acted in self-defense and I attacked them with a knife. Now the knife was never even brought to the knowledge of the inquiry. In fact,
it is there. All these are there. Everything is there.
only thing is
And the two sons, my lord, the sons of the deceased, they were sleeping in the same floor.
No, they came out, my lord, when the doors were big.
No, in the same floor. Because he was under surveillance, they said, for 2 months. They knew each and every movement.
Lord,
now, isn't it the intelligence?
White was staying in the ground floor and they all came out with the noise. He was the only one who was not coming out. He was the only one. That is also there. Everybody, when the police was banging the door, the wife has also come out. The statement is there, my lord. Everybody was there.
Of the records, if they had listened to us, what we said that as soon as the lights came off, then if he had charged the police and he was shot, it's understandable in self-defense. But the case of the police is that it was in the dark. They didn't know anything.
The corridors was definitely dark, my lord. Corridors in the first floor.
what time did it happen?
2:55. 2:55. 2:55, my lord.
Yes.
Your Honor, I pray that the matter may come up after 3 weeks.
I may bring for respondent number 4.
You ready with the matter?
I am not ready, Lordship.
Not ready. Who's the leading counsel? Who's leading you in the case?
Adjournment, sir. Adjournment.
Mr. Devnath, he's not here. He doesn't want to do this case. He doesn't want to do the case. No? Mr. Devnath, what did he tell you? He said, I don't want to do the case, you go and take adjournment. What did he say? He said that. Yes, that's very frank. It's this matter for 3 weeks.
Much obliged.
34.
What's your name?
B. Kong Young.
B. Kong Young. I don't. very frank. She said that she said don't do the case. Yes, but that. Yes, Mr. Dr. Mozika.
My lord.
Work finished. That day you were not here, then the.
Well, the work is not. Work has been allotted to. It has been retendered and allotted to another contractor, my lord. My lord, my instruction is to cut short the matter, my lord. His pipes are still lying there, my lord. He can collect those pipes. We have no objection to that. As far as.
That listing.
As far as any claim, my lord.
Debarment.
My lord, debarment also, if you lordship reduces it to till today, my lord, we have no objection to that also.
Yes, see one thing, Mr. Chareso.
Because he is also a big defaulter, my lord, in the entire contract.
See certain circumstances also. Why are you defaulting so much? Not a diligent contractor.
Those allegations are there, no doubt. Allegations are there. Only the judgment, my lord.
He can collect the pipes, my lord.
Yes.
Debarment can be reduced. And as far as other claims, because if he wants to raise some, the arbitration clause is there, my lord. If he wants to invoke that, he can. We have we are not saying anything on that, my lord.
But the two judgments earlier also lordship allow me to place. The two judgments regarding blacklisting. May I just place it?
That is my offer for out of court or a concession, my lord. He was referring to judgment.
We'll see what judgment we have. But broadcast services. It's not blacklisting in your case.
But it
debarring.
Debarring amounts to blacklisting, my lord. Blacklisting. And those two judgments are very clear. The content of the show cause, my lord, was implied.
Only in your department, not anywhere else.
Now, he has passed the debarring order. Now, the person who passed the order has circulated to all the central agencies, departments. The intent of the officer is very clear, to harm the petitioner. And view of that, my lord, he is not engaging any other more contract.
You already given this judgment?
But only I've given a lordship allow me to SSC, my lord.
The other one is.
And one is with Cuenca security.
Same one. You only give. You give the. You downloaded ones.
My lordship may kindly ignore those.
This you already given, yes.
My lord. And these two judgments, I will not take a lordship's time. But it's very, very clear.
Pipes, how many pipes do you have left?
Well, number of pipes are lying there.
You collect them then?
My lord, if lordship permits me, my lord.
Any other claim for damages, you go to civil court?
My lord, that portion, my lord.
That remedy is open to you.
My lord, I have
moreover,
it means that you didn't do the construction.
I have a point, my lord.
Page 109 of the writ
The
petition.
clause I have pointed out earlier that permits me to go before the officer.
Page 109.
After the officer passes an order, I may go to civil court if not satisfied. Those provisions are subject to lordship is satisfied.
Yes.
But this is the impugned order, my lord. It says, as approved by the competent authority, so and so, so and so, is hereby debarred from participating in tenders of BSF Meghalaya Frontier and under command headquarters for a period of 3 years.
No, but his grievance that you sent to ICAR, you sent to NEPA, you sent to this army, you sent to.
This is absolutely unusual.
But it was not necessary, my lord. But
yes,
but the department is only that.
Yes, the petitioner. Is the company or is this a firm?
It's a firm only, madam. It's a firm only.
It's a proprietorship.
Yes, the petitioner, which is a proprietorship firm, was awarded with work for installation of a tube well at the BSF campus Kompling Shillong. When was this awarded?
My lord, page
11/8/22, my lord.
2022-23, it
On?
says, my lord.
11/8/2022.
On 11/8/22, and the scheduled time for completion as per the agreement was?
It will come to 60 days from the date of commencement, my lord, and date of commencement was 21/8/22.
No. Property firm is. Was 60 days.
60 days.
From the date of commencement. That is 27/2022. Oh no, sorry.
My lord, actually, site was handed over on 14/12/22.
Yes,
60 days from
60 days, time of completion stopped. The site was then handed over to the petitioner firm on
14/12/22.
On 14/12/2022.
So the 60 days will start from there.
It appears that after the work had commenced, certain issues arose with regard to the implementation of the same, which, according to the respondent, in spite of requests for proper implementation of the same, the borewell could not be completed due to the unprofessional approach of the petitioner towards the work, and also the use of inferior quality of casing pipes, which were not found to be as per the specification of the tender conditions. Stop. The performance of the petitioner, as per the respondents, being below benchmark, disappointing. The work was then rescinded by the competent technical authority on 36/2023 in accordance with clause 3 of the general conditions of contract, which also resulted in the forfeiture of the performance guarantee deposited by the petitioner firm. Stop. The respondents, after rescinding the contract, then we are at page 101.
109 million.
Then by, this is before rescinding contract, correct? It was after. By an order dated 27/6/2023, debarred the petitioner firm from participating in tenders of BSF Meghalaya,
Frontier, Meghalaya Frontier.
Meghalaya Frontier, BSF Meghalaya Frontier, and under command headquarters for a period of 3 years due to poor performance, inordinate delay, and lack of interest in the execution of work. The petitioner firm, being aggrieved with this debarment order, which has affected its business activities, is before this court seeking the quashing of the, what other praise we have, Mr. Counsel? The quashing of the said order. And also for release of arrear bills as per law. Stop. Next paragraph. Mr. H.L. Sangreso, Learned Counsel for the petitioner. Where's my note? I submitted that. What is submissions, Mr. Charissa?
The opportunity was not given to him for passing the impunity order, my lord.
Submits that adequate opportunity was never afforded to the petitioner to repel the debarment order, and that in fact the petitioner had taken all steps to complete the execution of the work. But you get a lot of replies here submitted to them, and they show cause notices.
Yes, they also issued several show cause notices, and I replied, and they extended the time again, and finally they passed that order.
Yes, if the Council further submits that on the notices with regard to the progress of work, replies had been submitted, and extensions also provided by the respondents to complete the work. But however, the impugn order had been passed. What else is there in your submissions? Your petition also? Yes, but however, instead of just terminating the contract, the resort of the respondents to debarring the petitioner, which amounts to blacklisting, is arbitrary and discriminatory, and as such, the impugned order deserves to be interfered with by this court in exercise of powers under Article 26 of the Constitution. Next para. Dr. N. Mozika, London Senior Counsel with so-and-so, on behalf of the respondents, has submitted that this extreme step was taken by the respondents in view of the fact that, in spite of the completion time being limited only to 60 days, show cause notices, first show cause notice under clause 3 of the agreement had been issued as far back as on 10/1/23.
Well,
and a second show cause was also issued on 6/2/2023, which was followed by a letter dated 24/2/2023 to complete the work. The Constitutional Council stop. The Constitutional Council submits that, in spite of the repeated letters addressed to the petitioner to expedite the process, which is evidenced by the subsequent letters, Where are those letters? I've put my note this page 98.
the letters were dated 2nd May 23, 11th May 23, my lord.
Second?
2nd May 23.
The third show cause is on
On 20th April, my lord.
As there was no response on as there was no progress, a third show cause dated 20/24/2023 was issued to the petitioner. But however, one more opportunity in the said notice itself. Oh no, sorry. But however, by another letter on 2nd May, the petitioner was allowed one more opportunity to complete the borewell by 8th May 2023, which, however, was not complied with by the writ petitioner. So, Julie asked them to withdraw the show cause, nothing else.
Well, since they have handed over to other third party, if they revoke the impugned order, that will serve my interest.
So, he therefore submits that the action of the respondents, where do you cancel the work, rescinding the work on, where's the order? Page?
That one they have annexed in their affidavit, my lord.
Where's your? It's not here in your writ petition.
My lord, they have annexed in the affidavit, in their affidavit.
Whose affidavit?
Respondent's affidavit, my lord.
That's at page 151 of my affidavit.
In rescinding 151.
151.
Rescinding the contract. Wide.
This 30th June, my lord.
The communication dated 36/2023, which was a final action under clause 3 of the agreement, and the order of debarment were perfectly justified in the facts and circumstances of the case. Next paragraph. The third level counsels for the parties and also perused the materials as placed before this court, as submitted without reiterating the facts of the case. The writ petitioner, in the execution of the project of the contract, due to certain personal difficulties faced, failed to execute the same within the time provided. Stop. A perusal of approval of clause 3 of the general terms of contract. This is called general terms of contract. No, this is called
General
conditions. Or general conditions of contract, under which, by which the petitioner, by which the contract was terminated and the petitioner imposed with the debarment is perused, and for the sake of convenience is reproduced herein below. Stop. As observed earlier, the work was to be of duration of 60 days, and which was handed where in the site for execution of the project handed over to the writ petitioner on
20th.
Is it 28th? On
14/12, 14/12/22.
on 14/12.
14/12/22.
14/12/22. So we should complete it when? 60 days?
14/2/23.
No? Meaning which, if the contract had been diligently executed, the same should have been completed on 14/2/2023. Stop. However, it's noted that from 14/2/23 it means. Sorry. However, it is noted that on the slow progress of the work, the respondents from 10/1/23 itself had been issuing repeated reminders and also show cause notices to the writ petitioner, which, as per submission of Lancia Council, was due to the acute scarcity of water in the BSF campus. Stop. The facts as they pertain, therefore, which are undisputed, is that the contractor, for whatever reasons, the petitioner, for whatever reasons, had failed to execute the contract within the stipulated time, and as such, as per the general condition of contract, was culpable was culpable. Stop. Though reasons have been shown in the writ petition, you've shown reasons, right, as to why the contract could not be executed. Though reasons have been shown as to why the contract could not be executed in time, this court will not examine the same as these facts in the realm of as these are in the realm of disputed facts. Stop. Next paragraph. The only issue that this court will examine is whether the infliction of debarment by the respondents upon the writ petitioner in these circumstances is justified or whether the same can be said to be arbitrary and arbitrary, can be said to be arbitrary, yes, and punitive. Stop. Coming back to clause 3, as quoted above, though the same has invested the respondents with powers to terminate / determine the contract, and also the power to impose the contractor from future contract processes. In the instant case, the contract was, as noted earlier, for a deep tube well, which should have been completed on 14/2/2023. Stop. The trail of communications, as seen, no doubt reflects the urgency of the project and the deficiency of the contractor in executing the same. Stop. And it's in the same. Stop. This court, in a considered view of this court, however, the acts of the contractor, where's the judgment? You have not brought a court judgment, this court also.
My lord's order is also the My lordship order is also the
Yes, in the considered view of this court, on examination of the show cause notices, especially after the third show cause, when the letter dated.
My lord, the last is page number 104.
No, 1 second. Where they give you more time?
Yes, that is 17 May 2023, page 104. In the writ petition.
Yes.
They have given me.
The third show cause was dated when?
My lord, the third show cause is dated.
Yes, sir.
20
The third show
April.
cause dated 24/2023.
Yes.
Sorry. It was dated 24/23. Though that is at page. Though
the notice, third notice.
Yes, though.
Third notice is 98.
Notices, another 2 more notices.
No. This third notice, I'm going to third notice only, 24th. This is 24th April, correct?
Yes.
20th April.
20th April.
No? Dated letter, dated 24/23, whereby action was proposed to be taken under clause 3 of the agreement. The respondents, however, by subsequent letters dated 2/5/23, again
17 May, 17 May.
2/5 and
17
allowed the petitioner extended time to complete the work. This, therefore, had watered down the show cause notices of the respondents with regard to the completion and the action proposed to be taken. Next paragraph. As now been informed that after cancellation of the work, the same has been re-tendered, allotted to a third party who has also since commenced the work. Whatever reliefs the petitioner is entitled to would only be with regard to the debarment notice and not continuance of the project. Accordingly, the debarment notice dated 27/6 June 2023 is hereby set aside and quashed, and consequently, as very submitted by the DSI, the petitioner will be at liberty to remove whatever building materials, whatever some materials
lying within the premises,
belonging to the petitioner, such as pipes, etc. Within
15 days, we will.
Within 15 days from date of this order, stop. Any further grievances that the petitioner might have, the petitioner liberty to access the same before appropriate forum and to seek civil law remedy. Yes. With the above noted, as ordered above, matter stands to dispose of. Yes.
Obliged.
Do you want to do at 2? Do at 2.
37.
You ready?
Well, I'm ready, my lord.
Yes.
By
Your Lordship, I'm so sorry. I did not aware that
Who are you? You
case
are
is
the petitioner?
listed.
Correspondent number?
Number 6.
Respondent number 6, Your Lordship.
She's made a request to me also. It seems that she was not aware the matter is fixed today.
So, Your Lordship, kindly let this matter come on
2 o'clock.
Thursday. On Thursday, Your Lordship.
Who's leading in the case? You're arguing it yourself.
Yes.
Thursday, I'm okay with Thursday, my lord, because she's already requested me. I do understand, but Thursday is fine.
Okay, on the joint prayer of the this matter on. Doing this on Thursday because the matter let it roll over the next week, after 1 week. Because then it disrupts the hearing pattern.
My lord, next week.
42.
Yes, Mr. Pathak.
42, my lord, pertains to promotion. The petitioner was due for promotion to the rank of Nayak Subedar. My lord, in Assam method, they say that if you are posted on an extra regimental employment, which is ERE duty.
1 second.
ERE duty.
Now you are warrant officer.
My lord.
What happens with ECRs only?
But here what has happened, my lord, I'll just take your lordship to the one paragraph only, my lord. At page 6 of my affidavit, my lord.
Page?
Page 6. In fact, from page 5, I'll read the sub-para E, my lord, the entire paragraph.
Page 6, the affidavit.
Page 5, my lord.
Yes.
Now, my lord, if lordship kindly looks at next page, my lord, there is a table provided, my lord.
Yes.
Now, here your lordship will see these are the 5 years which are taken into consideration, my lord. Now, what happened? He is recommended in all the years, my lord. But his only problem is that in the last column, my lord, all the his reports are from ERE. ERE means, my lord, extra regimental employment. Now, I'll read to the previous paragraph, my lord. Para E, my lord.
1 second. Okay, he was not attached authorities at that time, the last 2 years. So how
last 4 years.
Then how can he be prejudiced because of that? There must be some other modality for you to.
Well, the rules say, my lord, if I may take you to lordship to the rules, my lord.
Page 36 of the affidavit filed by the Assam Rifles.
Page 36, the serial number 3, my lord. This is for
He was with which organization?
Well, I was in Assam only, but then I was posted in the sector headquarters in the Manipur region. So even if, say, for example, I'm posted in Shillong, which is in the DGAR headquarters, in that case, it is considered an ERE duty because I am not attached to my battalion during that particular period.
So why you don't consider what happens? Who writes the reports then when they attach to not attach their own unit?
It appears, my lord, the reports are submitted by where he was attached, my lord.
So who writes them then? Who's the accepting authority? Reporting will be the unit where he's serving.
Well, serial number 3 at page 36, your lordship, kindly see, my lord.
Yes.
This is warrant officer to NAB. This is what he's claiming, my lord.
One officer GD2. He's already got 15 years of service. 6 years of service. Sorry.
My lord. Now, at the fourth column, my lord, 3 out of last 5 reports should be not be below the high average. So that is meeting, my lord. Remaining 2 reports, there is no issues with that also, my lord. The problem is with the clause C, my lord. Out of the 5 reports, 2 reports must be from the battalion, ARTC&S or NSG.
So where was he at that time? The last 2 reports.
My lord, he was
with NSG.
No, my lord. He was with Assam Rifles, but he was on extra regimental duty with.
Then who writes the report? Who's the reporting officer? Because see, a person can't be deprived just because his extra regimental duty doesn't mean that his years in service won't be counted or his ACR won't be counted towards promotion if he's eligible otherwise.
My lord, that aspect of the ROI, my lord, has already been dealt with by the Meghalaya High Court. I had given a copy of the judgment in Annexure 6, my lord.
Then you come yourself, Mr. Pathak, we'll conclude it. Yes.
Page 23, my lord.
Mr. Pathak, you come yourself. When can you come? We'll conclude it, yes.
My lord, on 22nd, my lord.
22nd? Yes. Dr. Mosika is not keeping that well also, yes.
43?
Yes. Just a matter of 22nd for further hearing. Hold on.
This is that medical seat matter. Lordship said by an order dated 25th of October directed the records to be called for.
Lordship.
Where's that what officer who took leave and who said that in that very strange kind of affidavit?
Lordship, we have extra copies of.
Why are you blaming a poor assistant?
Lordship, we just placing the facts before this honorable court, my lord.
Let's see. They've taken out 2 o'clock, 2:15.
Lordship.
Can't sit for too long also. Yes. Yes.
Lordship, as per the last order, Lordship, this Honourable Court had inquired and asked for some supporting documents, my Lord.
Just one document as to how the whole thing happened.
My Lord.
Yes. Entire records, these are the original records.
Lordship, we don't have the original with us,
Then?
Lordship. These are scanned copies. Show you original. We've just received the scanned copies, my Lord. Petition.
So I don't understand. She has, you see here, prior letter 11/7, second list is on leave on June only. Then
Lordship, as per our affidavit,
29/4/85, 17/5. See, this is.
my Lord, these are pertaining to the long leave of absences, Lordship.
No,
but
I mean, is a poor assistant responsible for deprivation of a seat of a deserving student?
my Lord, we have placed.
That the entire process, I said, not only this. You kindly see the order, MS Chilla, the last order. Just see the order sheet. See.
Lordship.
See the order dated 25/10 to call entire records regarding admission for the said seat and also the leave application, the medical certificate of any said assistant who is unnamed.
Lordship, I apologize. I'll write to the department for the entire records.
Because the thing is
Lordship.
that, see, what has happened that the fate of two
My Lord,
candidates is, why this code is one to know. Because
Lordship.
these things shouldn't happen,
My
that's
Lord,
all.
this shouldn't happen. True.
You see, I mean, if there's another deserving candidate, I mean, this candidate would never come to the picture at all.
My Lord.
Now, whatever they say, oh, they came from the back door, they came front door, that's immaterial. Now, if there are two deserving candidates, then they should be given a level playing field. Now, you can't give a person a seat, they go and join. Now, without notice, you can't just cancel the seat also. They'll destroy their life.
Lordship.
And the other person also, maybe it's applied, maybe it came later on. I mean, the reasons should be transparent. And if you cannot, the seat already gone, you should make provisions to, if the person deserving, there's surely another vacancy somewhere.
Give us some time, my Lord.
Otherwise, it can't go on like this.
My Lord.
But you see, maybe someone just put in there. What happens in DC, someone known somebody, okay, put them there. Or sometimes cancel it again. It's happened earlier on also.
Lordship.
Whereby a person has joined and doesn't like that course. Then because of having influence with the, powers that be, comes back and says, no, I want to join another course. And they also give the order, and some other person who's come number one in the waiting list, full hope of joining is cancelled. So that thing shouldn't happen.
I pray for some time, my
You
Lord.
just take, as per order dated 25/10, by order 25/10/2024, this court had asked for original records. Regarding admission for a said seat and also the leave applications of a said assistant. Today only the leave application and some documents have been produced, but the documents regarding the admission process has not been produced. MS Angela submits a duplicate evidence. Accordingly, this is a matter of 1 week. The entire records will be produced on that date. And we have to call the officer, whoever is through the DHS.
This is the Joint Secretary, my lord.
Lordship will produce, my lord, on the next date.
The interim order may kindly be extended till such time.
Much obliged, Lordship.